Hello, everyone, and welcome to Uncivil Law, where, as always, we learn through the misfortunes of others. I am your host, Uncivil Law, and we are here with our continuing coverage of the Alex Murdaugh trial. And I want to start right away with some testimony from yesterday because there's been a dispute on the internets. No, not a dispute on the internets. There has been a dispute on the internets about some testimony yesterday. We have heard this long interview that Alex Murdaugh did with the police in the days following the shooting, where they were asking for permission to search his phone, which he gave, and asking for permission to check his DNA, which he gave, and other things. But there's one key part of testimony that's been disputed. It is the Laurel and Yanni of our time. Is the dress gold? Is the dress black? That is the dispute, right? So there's one part of testimony, and the question is, does he say they did him so bad? Or does he say, I did him so bad? Exciting. So in order to resolve this exciting, fun issue, we are going to listen to this clip from yesterday a couple times to see if we can deduce what he is saying. And I will just kindly remind you that this is Southern, so there's that factor. So, but let's listen to this little bit of testimony from yesterday and see if we can deduce what was said.
And sitting here talking today is tough.
It's just so bad. They did it so bad.
You asked the defendant about the traumatic picture that he saw of Paul and Maggie. What did he say?
It's just so bad. I did him so bad.
Is that what he said? Let's listen to it again.
And sitting here talking today is tough.
It's just so bad. They did it so bad.
You asked the defendant about the traumatic picture that he saw of Paul.
One more time, guys. Let's do it again.
And sitting here talking today is tough.
It's just so bad. They did it so bad.
You asked the defendant about.
Nah, I'm going to need to hear it one more time.
And sitting here talking today is tough.
It's just so bad. They did it so bad.
I'll tell you what. If you're asking me, I think he's saying they. That's what I think. I think it's they did it so bad. But I can understand how a person would think I can get that from it. But if you're asking me, I think it's they. So that's sort of my my ear on the issue. So yeah, but that's what I heard. Yeah, and I've listened to this clip as well this morning, and definitely also heard I. But when I'm listening back to it now and listening back to it back to back to back, I'm hearing they.
And sitting here talking today is tough.
It's just so bad. They did it so bad.
You asked the defendant about the traumatic picture.
I don't know, man. I don't know. I think they. I don't know. I think they, but you think so we'll take a look at your votes. Slow down speed. I mean, if I slow down this, I guess I could slow down the speed. I'm not sure that would help really, but we can try it once with a slower audio. Play down. We can turn the play down speed to 0.75. See if that helps at all. We'll give that a shot.
And sitting here talking today is tough.
It's just so bad. They did it so bad.
Yeah, it doesn't really help me very much, but maybe if it does something for you. Maddie says, to be honest, I've heard both, but on first learning, I heard I. Yeah. Lisa says, it's just so bad. They did him so bad. That's closer to what I'm hearing. For sure. Lulu thinks it says I. Mimi says it's just so bad. I did it so bad. I don't think I hear I think it's they. We could slow down the audio even more at 1.5 for all the good it will do us. I'm not sure how much it will help, but we can slow down the audio to 50%.
And sitting here talking today is tough.
It's just so bad. They did it so bad.
Yeah. Nathan Laura, have you heard this critical audio from yesterday on the I versus they thing?
Yeah, I did it so bad. I did them so bad, right?
Yeah, that's what we're discussing, whether it's I or they. That's what we're trying to decide, at least in chat. Because I think it's close. I think either one, but I think on balance, I'm hearing they. But there was some dispute on the issue for sure, and I thought we could start that way by discussing what we're hearing or not. Stephanie H. They. Go ahead.
Well, I at this point though, if you're asking me beyond a reasonable doubt, we're what 2 days in to
Yeah.
the prosecution's case, and I
Yeah.
am no farther moved that this man is guilty beyond a reasonable doubt. Like even it's a little bit moved. I'm kind of still in that that phase where I'm still looking for something. This video is attempted to push me a little bit,
Yeah.
but still, it seems like, to be honest with you, the defense, just for my first 2 days watching, the prosecution is just putting on a boring case, and their case is being kind of shredded apart by this defense team. But second, the defense team seems that they're not really prepared, because yesterday's was like a debacle of you don't have your exhibits prepared and all that type of stuff. But I think but the defense doesn't have to prove anything. It's the prosecutor. So
Damn straight.
as
Damn
right
straight.
now, they haven't proved it. But obviously it's a 3-week trial, so there's going to be more to go. But I just don't see anything that is here to what I'm saying. They haven't proved anything to me yet, as of yet. Now this is coming. This is trying to move the needle. But if this is the best they got, then we're going to need more.
Yeah, and I mean, even if it is I mean, that could be a lot of things in context, to be quite honest. I did it so bad. I mean, what is that? What are we referring to? What is the antecedent reference? What is the thing that I did, or in this context, would be a little bit open to interpretation. The best evidence they have presented so far, at least, is that the head stamps of the ammo that was found at the murder scene matches the head stamps of ammo that was found in other weapons that was kept by the defendant in his home. So same manufacturer, same caliber. That's, I guess, partially suggestive. I mean, there's 300 blackout is a very common round. A lot of people make it. The rounds that they have in their house are they're like the most common manufacturer, like known to man. But maybe that's somewhat suggestive. Where they want to go, and we haven't heard this testimony yet, except in prelim, or it seems where they want to be able to go, is they want to be able to say that the Murdaughs have this their own personal shooting range, because they have a big ass piece of property. They have a shooting range that's on their property for them personally, and they recovered spent casing from that shooting range that matches the casing that was found at the murder scene, and they want to be able to say, based on examination of the casing, that the tool marks are such they can say the murder weapon must have been a weapon that was also fired at the private shooting range. And because it's a private shooting range, ergo, it must have been one of the Murdaughs, ergo Murdaugh. It seems to be the idea that they seem to be setting up for, but we haven't really gotten that far yet.
Yeah, when you're dealing with a circumstantial case, as we're dealing with here,
Yeah.
The problem with circumstantial cases is that the prosecution, there's a little analogy I like to bring it to, in which like it's unfortunate because everything can seem one way with a circumstantial case, but then you can have like one piece of evidence that explains it all and that destroys your circumstantial case. And I think the problem here is that the DA, and you know what? I hate talking like this without explaining. What do I mean by circumstantial case? Essentially, all evidence is circumstantial. It's direct evidence is you see the person shooting the person. You have a video
Mhm.
evidence of that's direct evidence. Circumstantial evidence is not you see the person shooting the person. It's kind of you hear a gunfire and I walk out the room. So you can infer that you have to have that inference that I was the person that shot the gun. You didn't see me, but you had that it's circumstantial. I just happened to be in the area. The gunshot went off. Somebody was killed, and you saw me. That's circumstantial. The circumstances lead you to make an inference. If you have to make that inference that I did it, versus you can directly say he did it because he shot the person. So
Yeah.
that's what this case is. 100% circumstantial, right?
Yeah.
It's this father who was there, and they're saying based on all these other reasons, we can infer. We have to make an inference that he committed this murder. Now, in that vein. Circumstantial cases are the most dangerous cases for prosecutors because here there's no murder weapon. There's no this. So when we're talking about same type of bullets being same, they're trying to essentially make that leap, that logical leap. But the problem is that these are very, very these type of cases, even if you do get a conviction, they're very susceptible to appeals. Because they can say, well, even the jury made that inference, but that's not a proper inference to make beyond a reasonable doubt, right? So all this evidence that you're talking about seems compelling but you would have to accept that inference that he did this. Like, the most popular round, the most popular gun, he has a shooting range, he has many guns. They've not got the murder weapon, they've not got any gunpowder, they've got almost nothing.
Yeah.
So they're trying to put this thing together, but they need something better than this because again, circumstantial cases are generally losers, and I think this one is looking that way.
I tend to overall agree. Especially, the absence of evidence is what they've got. It's like he's got all these other guns that are in those calibers, and the murder weapon must be one of the guns that we didn't find. It's like, what? That's great. Or where are the bloody clothes? Oh, we didn't search the house for 3 months, so he must have buried them in a field. What? This doesn't work for me when we're trying to convict a person beyond a reasonable doubt of murder. So I think right now the state's in a bit of trouble.
Yeah, they are in a bit of trouble, and this, I think, this is this is going to motive, conscious of guilt. Essentially they're trying to say this is a confession. Right, but even the confession is circumstantial, which is it's crazy when you got a circumstantial confession. You got to make this logical leap to determine that it's a confession. So yeah, so I think they got a lot to overcome. But we're only but saying that we're only 2 days in, and this is one thing I'll tell you. And for those of you who want to be lawyers, if you are arguing, if you're a prosecutor, or even if you're in a civil case, this is why we talk about recency and primacy, right? This is why we talk about start strong, end strong. The prosecutor here has been putting their case together through a timeline. In other words, we're going to start with day 1, day 2, day 3, day 4, day 5, which is fine, which is generally what you'd like to do. But a good prosecutor or great prosecutors, what they do is they'll put evidence on that's most compelling at the beginning and they're most compelling at the end, and then take you on a timeline through the middle. So you'd have heard this tape day one. Day one, you'd have heard this tape. Here's the tape, blah, blah, blah. And then while we're all sitting here thinking, was it was it they, was it a confession or not? Then you start talking about the evidence, right? Then you start talking, because that's now in your mind that he may have confessed. And anything that, and what you do is you put the juror in the role of investigator, because everyone loves to solve a mystery. So that one little piece of evidence, now you heard this, you're not too sure, any little piece of evidence between there and the end of the trial, I got it. He obviously said because of this piece of evidence, and they feel that they solved the case and you got a guilty verdict. But they're not doing that here. They're taking you through this long, drawn out process, and it's boring everybody to death. And they haven't convinced anybody. And day two, if this is the best you've got, I think they have to rehabilitate their jury and get something in there better, because again, these jurors are just like us. They're watching this stuff, they're bored to death, and they're going to be going home every night thinking the same thing. What the hell happened? And if they're saying that, you're losing.
No, yeah. If you're explaining, you're losing, and this is a lot of trying to explain things. Where show not tell is always a good rule for trials and just generally, and also for YouTube videos, as we've been talking about recently.
Yeah, it's a show and tell. So it's all about
Yeah.
show. Because telling is great, but it's all about the show.
Yeah, it's like, where's the murder? Where's the murder weapon? I've got all these other guns. Okay, that's great. Where's the bloody clothes? Nothing. Where's whatever, and it's like, yeah, not so much. And the state, I think the state, in terms of the presentation of evidence, is doing fine. I just think that their underlying case is really weak, and that's not necessarily the prosecutor's fault. That might be the fault of SLED, which blaming SLED is always a good option in South Carolina, because SLED has a reputation this fits in very nicely with, of being a little bit incompetent, a little gung-ho and a little incompetent. Nice combo for SLED. But yeah, I think that this is more on the investigation, more on not securing the property properly, more on not doing a search that apparently that evening, not searching for 3 months.
You know what we call this? We call this the OJ.
Yeah.
He's hitting him with the OJ.
Yeah.
OJ got off not because he didn't do it. It's because the police were so incompetent at collecting evidence, at doing this and doing that, right? If the glove don't fit, that's all about the evidence, right? They attacked the evidence, and that's what this defense attorney's team. Why didn't you get the other shoe prints, right? We're saying somebody else was there. Somebody else killed them. You see other shoe prints? You didn't pick up. You didn't preserve those. You didn't preserve the other tire tracks.
There was a bloody footprint, which was one of the cops. That's nice.
Yeah, like, you guys have destroyed all the evidence. So,
yeah.
Nate, would you have brought these charges with these facts? I may have. I don't know if I would have. I don't know if I would have, but I would be trying it differently though. You would have heard you would have heard some of my best evidence day one. Day one, we're putting on the best evidence, and then we're walking you through it, because I want you guys, because it's putting the audience in a position, in the right frame of mind to make an argument, because that's what law is, right? I know we all want to be aspirational and things of that nature, but it's also a performance, and you want to put your audience in a particular state of mind so they can absorb the information the way you want them to see it. They want them to see this guy's a guilty man. You play that tape day one, people are thinking he may be guilty. And then everything else they try to fit all this other evidence into that guilty box. Now, day three, you're like, I don't know if he's guilty, and I don't know if this tape helps me. That's what I'm talking about. Putting your audience into the right frame of mind, putting your jury right into it. And again, if people think if people hate me talking like this and talking this nonsense.
No, it's good stuff. It's good stuff.
I'm just telling you the way I would do it.
Yeah. This is stuff we've definitely been talking about as well over here. The importance of storytelling, and storytelling with the evidence, and primacy and recency, and making sure trying to fit what you want to do is fit your available facts to your overall theory of the case, your overall narrative, and lay it out in a way that helps tell a story, preferably with some sort of story arc would be nice.
I'm out of the super chat doghouse. Have a dozen eggs on me.
Thank you, Liz, for the super chat, for the $9.99 for the eggs. I appreciate that. I can now afford eggs. It's fantastic. I appreciate that. But yeah, we've been talking a lot about that with storytelling and how trials are stories. There's an infinite number of facts that are possible. There's a lot of things that are happening in the world just generally, that you could theoretically talk about. Something probably happened in Tanzania the night of the murder. That's factual, but probably not relevant to this, right? So, that's an absurd example just to prove the point, right? About how there's facts that are lots of things you could be talking about, but you don't want to do that. You want to bring in the relevant facts. What are relevant facts? Well, the relevant facts, at least from your frame of reference as an attorney, are the facts that help fit a narrative that best serves your client. And so what you want to do is you want to tell a story that helps to string those facts together in a nice, pleasing way that helps to tell the story. And that's sort of the ideal. And yeah.
Here we go.
Yes, sir. Say this. Your Honor, can I just make one brief comment?
Yes.
And I've talked to all of us over here. We want to thank the Clerk of Court for her assistance every time we need something. She has been there for us. The Colleton County Sheriff's Department is providing security has given us total access to our client. We feel like we've been
what's
treated extraordinarily well by
what's the
all
point of putting this
court
on the
personnel.
record?
And I want to put on the record, since there seems to be a national media interest here, I've tried many cases in many jurisdictions, and I've never been treated at this level of courtesy and understanding. Thank you.
Now listen, I'm telling you why he's doing that.
Everybody's been great.
The
Absolutely.
reason why you do that is you see the judges smiling, everybody feels good. This is all tactical, people. This guy knows what the hell he's doing. This is all tactical. Look at the judge; he's smiling. Oh yeah, I got a good court here, right? You know.
Yeah, but I mean, you're taking away a potential appellate issue because you just said, "Oh, we've had perfect access to our client. They're facilitating every need. We're getting everything we need. Everything's great. Everything is awesome." I mean, so you're taking away a potential appellate issue by opening your mouth.
Well, you can, but now you can. But I think though, at the end of the day, you want a happy judge. Judge is happy with us. You know, it's this is all table setting. This is good shit. This is good shit. This is all table setting.
Fair enough.
Well, would you rather the judge be angry at you going with the jury coming in, or smiling and thanking you?
Your Honor, you're the best honor. We love you.
Oh,
we think
man.
you're the best honor.
You know, you're the first person to ever tell me that. Thank you so much. Don't worry, you're a good guy.
Hey, good morning.
We just want to put on the record how awesome your
Day
chair
number
is.
7.
We're jealous.
State's
Round
case.
closing like crazy.
We'll have our witness back.
Look at the judge. He's in a good mood. Look how he put the judges in a good mood. We ain't seen the judge smile in 2 days.
Okay. All right. Well, if that was the objective, mission accomplished.
Of course,
maybe
it was the objective.
maybe it's because we got a little bit yelled at yesterday. To the
table.
point where we opened ourselves up, to the point where they're like, "Hey, prosecutor, do you want to like just go the record how they're completely full of shit?"
Cross-examination. Mr. Griffin.
Good morning, Agent Croft. Good morning, sir. On June 8th, I understood that was your first involvement in this case. Is that correct?
Yes, sir, that is correct.
And you went to Moselle on the morning of the June 8th?
I was en route to Moselle, got rerouted to the office, and then went and conducted an interview, and then back to Moselle.
That's right. You interviewed Rogan Gibson and then went to Moselle.
That is correct.
And what time did you get to Moselle?
I was around lunchtime when I got there.
And as I understood from your testimony, that your role primarily is because in this case is that because you know a lot about guns and ammunition. Did I understand that correctly?
That was not my sole role. I was at the search of the residence because of my familiarity with firearms.
Yes, sir. And you went and searched the residence with other agents, and we saw those agents, some of them, on the body cam video that played yesterday.
Yes, sir. I was in the gun room.
And this search was a consent search, correct?
That is correct. Yes, sir.
And you weren't there executing a search warrant, right?
No, sir. I was not.
And were you aware, though, that there was a search warrant that had been obtained the night before?
I was aware of the consent, the search at the incident location. It's common practice that they get a search warrant to process the scene.
Yes, sir. Were there any limitations that you were aware of on the scope of the consent to search?
No, sir.
And so, as far as you knew and understood then and understand today, you or other agents at SLED could have searched that house from top to bottom on the 8th. Is that correct?
Other agents went through the residence with family members.
And there were no limitations on what the other agents could have looked for, right?
Again, I can't say what limitations was placed on them as they walked through the house. I was in the gun room.
Okay.
Fair enough.
Well, to your knowledge, did anyone look for bloody clothes or dirty clothes in the house while you were there on the 8th?
I was in the gun room and I was collecting guns and ammunition, sir.
Now you mentioned that you had been provided some information about the type of ammunition that was used down at the crime scene where Maggie and Paul were murdered. Is that correct?
That is correct.
And one one ammunition was a .300 blackout shell casing. Were you aware of that?
Yes, sir, I was.
And who relayed the information to you as the type of ammo that was used for the murder of Maggie and Paul?
It came from the investigative team. I don't recall exactly who called me or who told me the information, but I was relayed the information through our investigative team that was at the scene.
All right, so you were informed that, look out, see what you can find in the gun room related to .300 blackout. Is that correct?
It wasn't limited to specifically .300 blackout. That was a round of interest.
Okay. And then the other round of interest was 12 gauge, correct?
That is correct.
And were you given any information as to what specific type of 12 gauge ammunition was used at the crime scene?
I knew we had a 12 gauge, what believed to be a turkey load or BB load, and then a buckshot.
Okay. And let me talk to you a little bit about the .300 blackout ammunition. You testified yesterday that the grains, the weight of the ammunition found at the house was 147 grains. Is that right?
That is correct. That's what's on the empty box which I located. And
is this the empty box, State's Exhibit 213 that you're referring to?
That is correct.
And this, I recall, this pack of ammo on this exhibit has a label of Woody's Pawn and Jewelry and $11.99. You couldn't buy this ammunition in June of 2021 for $11.99, could you?
I don't know what the ammunition cost.
Well, it was a lot more than $11.99.
I don't know the price of the ammunition at that time.
All right. And are you familiar? There's basically two types of ammunition for the .300 blackout. There's the supersonic and subsonic.
I am, sir.
And the subsonic is the heavier of the two, correct?
That is correct.
And that would be a 220 grain.
Thereabouts, yes, sir.
Yes. And the most popular ammunition for hunting is the supersonic, the 147 grain ammunition. You aware of that?
I can't say the most popular would be, but I am aware that the 147 grain is used for hunting.
It's the most popular.
And you're aware that
goes to ship.
The .300 blackout has it's not a rare gun in the area of Hampton and Colleton County, is it?
It's not as common as the General 223 or the AR-15, 308, different caliber rifles. It's not as common.
But there are plenty out there.
But it's common,
correct?
I can't testify as to how many's out
He doesn't want to say it's common. He knows it's
It's not
common.
the first time you've seen a
You know the
blackout
answer.
on
It's
June
okay.
8th,
Yeah.
2021.
You can say
You
it.
know.
You know.
I had
It's
seen
okay.
one before, yes, sir.
Of course he's seen one before. He
And,
doesn't want to say it's a common gun. Uh-oh. Did we lose Uncivil?
From the information from the crime scene, right? Of the 12 gauge.
Am I coming in choppy?
I was given a 3-inch
coming to chop it?
3-inch
Here,
magnum was what
the
I
entire
was,
video disappeared
what I
for a
was
second.
And that was on the buckshot.
I was given 3-inch magnum of shotgun capable of shooting a 3-inch magnum.
Okay. Now, and we're going to get to some of these shotguns here in a minute, but
See, just so
That,
everybody knows, it hurts their case tremendously if he's using a popular gun with popular
the Browning
ammo.
light doesn't
That
even
kills your
shoot a
circumstantial
3-inch
case because their
shell,
case
does it?
is
It does
he's
not.
using
2
these
3/4
particular gun and
shoot.
particular thing. If it's popular,
And
then
yet you seized it,
I secured it, yes, sir.
and you brought it here to the courtroom and introduced it in this case.
I did, sir.
Yeah. A gun that couldn't even fire the bullet that killed Paul, right?
It did not fire the rounds that was
I
located.
like that. That's a good hit. I'll be right back.
In
That's
fact,
a good question.
none of the shotguns that you brought yesterday, according to the ballistic report, your lab analysis, fired the shots that killed Paul, correct?
I do not have the lab report in front of me.
Well, you certainly know that after June 8th, SLED was diving in ponds and waterways looking for the murder weapons. Isn't that correct?
We were diving looking for potential evidence from the scene.
Have you ever found the murder weapons, to your knowledge?
Objection, Your Honor. That's outside the scope of his knowledge.
Objections overruled.
Not that I'm aware of, sir.
Lol. We never found the murder weapons. Lol.
And are you familiar with what ballistics tests were done on Buster's 300 blackout, and whether that was excluded as a weapon used to kill his mother?
Again, I don't have the report in front of me, and I'm not able to testify to that, sir.
It's amazing how he suddenly doesn't know things on cross-examination, isn't it?
And you brought
I have
these
no
empty
idea. I knew all the
turkey
things on
load.
direct, but suddenly I don't know things.
Exhibit 214, I believe. brought these in evidence.
Evasive.
Box of turkey shells.
That is the boxes I collected, yes, sir.
And these were empty.
Yes, sir, they were.
And these were found in the trash can.
Yes, sir. They were found in a trash bag, yes, sir.
Okay. And you let's see. Exhibit. The other end has exhibit number. Exhibit 90 is the Browning Auto 5 Light 12 gauge, which we already talked about wouldn't even hold a 3-inch shell, but there was no shells, no ammo in the Browning weapon, which is exhibit 90 you brought to court, right?
There was no rounds in that weapon.
When you seized it on the 8th, no rounds in it, right?
That is correct, yes.
All right. The Mossberg model Ultra-Mag, which is exhibit 89, you have a 12 gauge shot shell written on the outside. So there was one shot shell in this, loaded in this gun, correct?
That is correct, yes, sir.
And you remember if it was buckshot or birdshot?
It was black. I don't remember what it was.
Will you be able to look at it and tell us?
Yes, sir.
All right, I'm going to hand you exhibit 89 and ask if you can pull out the ammo in there and tell this jury if that's birdshot or buckshot first.
It is a Browning 12 gauge, 3.5-inch Magnum, 2 1/4, number 7 and 9.
And that's for hunting turkeys, right?
That is my understanding, yes, sir.
All right, thank you. Put it back in there.
This is closer.
This in here.
No, sir.
Here we go.
Brandon, if he gets convicted, he's going to jail for life on a double murder.
So
Yeah.
in the Mossberg, there's one birdshot. Now the other, the Benelli Super Black Eagle 3, had 2 unfired shot shells according to your notes on the box. And this is exhibit 91, is that correct?
Yes, sir.
And do you recall whether any of these was birdshot, buckshot? Do you remember?
I would have to look at them again, sir.
All right.
Let's do that. Let's look at them. Because he knows the answer. Hopefully. Right? And whatever the answer is not what the answer the state wants it to be. That's the only reason you asked this question. This isn't the ammo, is it? No. This gun didn't have any ammo. No.
That was Exhibit 91, for the record.
There's a black round in here that's a 3-inch number 4 pellet, and then there's a 2.25 ounce 3.5 inch with an 89 millimeter.
And those are both turkey loads, right?
Yeah.
It could be used for turkey, yes, sir.
Well, let's just be clear. Neither one of those are buckshot, correct?
No, sir.
Thank you.
Yep.
And again, these were ruled out as having any involvement in the murder of Paul, right? Exhibit 91.
I can't testify to any lab reports. I don't have the lab reports, and it's out of the scope of what I did.
Was it correct to say, Agent Croft, that you did not find any guns loaded in the gun room or anywhere at Moselle that had a bird shot and a buckshot loaded at the same time?
The only weapons I've recovered are the weapons that are there with the rounds that we have just looked at, yes, sir.
And if you or another agent in your presence made a representation that we found in the gun room a gun with similar loads as that we found at the crime scene, that would be an incorrect statement, would it?
I don't think it would be incorrect to say that there was guns were loaded in a similar fashion using two different types of ammunition, 2 different loads.
Well, there's no buckshot in any of the 2 guns that you found loaded, correct?
Not when we collected them, no, sir.
And
Oops.
the turkey loads or the bird loads that we just looked at, those the pellets in those are lead, are they not?
I would have to look at the actual boxes that came in, or
Almost
the,
certainly, yes.
Pellets that are in it. Some of them are steel. I'm not sure.
So do you know the difference between steel and lead?
Do I know the difference?
Yeah. Yeah. What's the difference? Why would you have steel versus lead?
Lead's a lot denser.
Steel shot is used a lot in waterfowl hunting, that type of stuff. Lead shot is used for normal everyday rabbit, squirrel, dove.
Well, we do have some boxes here, 214. Can you tell us whether this is lead or steel?
The Winchester 12 gauge shot lock lead is a turkey load, number 4. The Browning box, I do not see it indicated on the box what the ball is or the pellets are.
Thank you, Sinbad.
Well, let me ask you, is there a turkey on the face of that box?
Comment. I tried
There is
really
a
hard
turkey on the face of the
yesterday,
box, yes, sir.
so
And turkey a
appreciate
waterfowl
that, thank
bird
you.
or land bird?
Turkey is a land bird, sir.
do you know that? Did you ask the turkey? Whether it identifies as a land bird or air bird? How do you know how the turkey identifies?
And the other box is
They
the
get-
same on Federal. It's got a turkey on the
Good.
front.
All right. So those 3 boxes look like they're turkey loads, right?
That's what it appears.
Okay. Did you find any waterfowl shell boxes at Moselle on June 8th?
I did not collect any waterfowl shell boxes from Moselle.
Did you collect any waterfowl unfired shotgun, 12-gauge shotgun shells at Moselle on June the 8th?
Not that I'm aware of, sir.
Have you ever collected unfired shotgun shells for waterfowl at Moselle in part of this investigation?
I do not recall collecting any waterfowl shot.
Are you aware, sir, that the shot that blew Paul Murdaugh's head off was Winchester dry lock steel waterfowl 12-gauge ammunition?
I was aware that the pellets were steel.
Uh-oh.
Well, you can look at the outside of the
No matching shotgun
of the
shells.
spent shell casing and see that it's Winchester dry
No
lock.
matching
correct?
shot type, at least,
If I had the shell case.
to any of the guns that were recovered at the scene.
And you know that to be a
Uh-oh.
waterfowl, a duck
Uh-oh.
load, correct?
No
I know that
matching
it's
shot
primarily
loads.
used for duck loads.
Uh-oh.
And you know that's what killed Paul Murdaugh.
I do know that it was steel shot.
You didn't
I bet
find
you know a
any
lot more than
similar
that.
ammunition at Moselle on June the 8th or any time after that, correct?
I did not, sir.
Now, you were showing pictures of the gun room and and I think you testified there were some 25 guns and gun racks.
It's roughly 20 to 25 guns.
And this is 1,700 acres of hunting land?
Yes, sir.
And, I mean, did it shock you to see that many guns? And they were all hunting guns, were they not?
It did not shock me to see that many hunting guns.
And a lot of people in...
It only shocked me how few there were.
Colleton, this part of the low country...
Thought maybe he was having tough
They
times,
hunt
his poverty stricken.
with those types of guns. Isn't that correct?
Yes, sir.
And nothing... You didn't find anything unusual about the number of guns they had in their house, right?
I did not, sir.
Thank you. Now, you mentioned that you know something about the injection pattern of the 300 blackout. You remember testifying about that?
I remember testifying that it ejects to the right and slightly backwards.
And I'm going to let you take it out.
Right-handed gun, ejects to the right.
I'm a city boy.
May I stand?
To the left.
Yes, sir, please. Do you mind, y'all?
It's amazing how on cross he suddenly doesn't know things.
Knows nothing. He knows nothing.
Oh, no. I knew all the answers on direct, but now I'm a little bit hazy.
Almost as like he's not an expert. And this is classic performance. Have him hold the gun.
Oh, sure.
While you're standing,
Here it is.
just step down and point the gun at that door, and hopefully no one comes through, and show the jury the direction that the shells would go.
Can I point it up further?
Point it up
than
would be
the door?
great. That'd probably be safer.
Yeah,
Told you.
that's a lot. Thanks for the gun. Thank you for the
The
discipline.
rounds would be ejected from this side across would be my right shoulder.
That's because you'll be holding the gun with the right hand.
And so, and it's a semi-automatic, I mean you have to pull the trigger each time, is that right?
That is correct, sir.
Yeah.
And every time you pull the trigger, it shoots, a shell ejects off toward your right shoulder, toward the rear, right?
As long as there's ammunition in the magazine.
And how far does it go before it lands, roughly?
I can't answer that, sir.
Foot, 2 feet, 3 feet?
I can't testify to how far an ejected shell is going to extend.
It's not
from
going
the-
10 feet. It's not going a mile, right?
Why not? Didn't you fire it? Didn't you test fire
Can you
it?
put it back, please?
That's true
Yes.
too. Oh, so you never test fired it, right?
Just what way you have
Rounds
that-
go
you
to the
point
moon.
To the jury, I think they saw it before, but let's just be clear. the thermal scope. Can you point that out?
This would be this item here.
And you've got to charge that, right? That's sort of you've got to plug it in, battery operated of some sort?
It would have some sort of power. I don't know if it's a rechargeable battery or batteries that has to be replaced.
Okay.
I know
And
nothing.
the thermal scope is for hunting at night, is that right?
It could be used for hunting at night, yes, sir.
A regular scope
To
is
pick
kind
up infrared, it's heat sensitive.
of hard to hunt at night with a regular scope because it doesn't pick up
Scope and a
infrared
light
heat.
would work, but this is also used.
Yeah. Okay. All right. Thank you.
Yes, sir.
The guy on cross is killing him now. Now all of a sudden he knows nothing. Before he knew everything.
300 blackout. I can't say it's a common round. I can't say it's common in this area. I'm only the ballistics expert for SLAD, but I have no clue if it's a common round in
Agent
this
Croft, I'm
area.
going to show you when
I know it's a common round in that area, and I don't even live there
Exhibit
anymore.
29.
But you lose anybody, any gun person on that
and-
jury, you lost them.
Can
Because
you-
if they know it's a common round, they know this
Can you
guy's
see it
being
from up there?
deceptive. That's why you got to be careful.
Yes, sir, I can.
And
If you're a gun nut on the jury,
These,
which probably
like
likely is somebody's going to be a
marker
gun nut
7,
on that jury,
5,
you lose that
6.
person.
I'll just, it's identified in the legend over here, but these are 300 blackout shell casings. Do you understand that to be the case?
He doesn't want to say it. He doesn't
I
want to
don't
say it.
see marker 5 on the printout on the left-hand side there.
He doesn't want to say it. You see, because now,
Right,
the,
it's
the,
not
and the
on.
thing is, when your witness is fighting on simple shit like this, it makes it seem more important than
Well,
it
let's
actually
just
is.
follow along.
You should give it up. Yeah, it's a common round. So effing what? But the fact that he's fighting on it makes
are
it
in
more
fact
important.
shell casings, from what you just described to the jury, the ejection path of the 300 blackout, where would the person shooting the gun be standing in relation to these markers? 6, 5, 6, and 7.
Objection, not qualified as an expert.
Really?
It's overruled.
Ah, overruled. He is an
Wait.
expert.
The state just objected to their own expert being an expert?
If
What?
7, 5, and 6 are shell casings,
From a right-handed
it
gun.
would be likely that the shooter would be to the upper side of those rounds.
Somewhere
Makes
near
sense.
this line in that area?
I can't testify to that line or any kind of angle of that line, no, sir.
Understand, but it would be on the side of the line. It'd be up in here somewhere, right?
It would be on the left-hand side of where those numbers are. It would be likely that the shooter would be on the left-hand side of where those numbers
But it's
are.
not
if you're looking
definitive.
at it
He needs
from
to
where
say
I'm
it's not definitive because it
The
could
shooter would be on the left-hand side of these numbers and a little forward of these numbers. Is that right?
Nah, you
I can't say because I'm not sure if the ejection hit something on the way out, or if there was an obstruction on the ejection. I don't know. I can't testify to how far they would go. I just know that a normal 300 ejects to the right and slightly backwards.
Yes, sir. Thank you.
Back and to the right.
Back and to the right.
Back
Hold on.
and to the right.
Oh, you were at Moselle on the 8th. I think we've established that. And did you go back on the 13th?
I did, sir.
And you went to the house on the 13th as well?
I did, sir.
Okay. And we saw body cam from where you're picking up shell casings around the side door, 300 blackout shell casings around the side door. And I think, was that the 8th when you got the shell casing next to the...
That was around 2 o'clock on the 8th, a little after 2.
Now, jury will have the video if they want to see it, but as you're standing out there, you could see the rooftops of the shed building and some other structures down at the kennels where the murders took place. You remember you could see the rooftops?
I would think you could see the rooftops.
But that's all you could see, correct? You couldn't see sled agents working around down there by the dog kennels.
No, sir, there's planted pines between the residents and the kennels.
So the fact of the matter is, you can't see people at the dog kennels from the house based on your personal observations. Is that correct?
From where I was standing, no, sir.
The voice inflection too. You saw he got louder. Make sure. Very important point.
Now,
This guy's
you
good.
also testified about the location
fine.
of Maggie's phone, how it was found.
Yes, sir.
Did you go out there when it was located?
Yes, sir, I did.
You recall how it was located?
Yes, sir, I do.
How was it located?
We sent information to the phone company for a ping. The ping was actually 20-something hundred meters, which is a long ways. We then learned that she had Find My iPhone on her phone. One of the family members assisted with locating that phone, getting a better location on the phone, and we were ultimately able to find it.
So you found the phone, Maggie's phone, by family member using Find My iPhone.
And I think it was John Marvin is the one that assisted us with that.
And do you think John Marvin was using Buster's phone to do that?
I don't have a clue what he was using.
And then when the phone was collected, you were provided the password. You remember you testified the password was provided.
We were provided the PIN to open the phone. Yes, sir.
Are you aware that Alex Murdaugh provided the PIN to SLED so they could open Maggie's phone?
Again, I don't know where the passcode or PIN came from, but we were provided a PIN.
But it doesn't matter. But it doesn't matter because the defense attorney already told you who provided it.
Do you know what a Faraday bag is?
That's a good question. That's a good question.
Yes, sir, I do.
Did anyone have a Faraday bag?
I did not have a Faraday bag that day.
What's the purpose of a
Did
Faraday
anyone
bag?
have a Faraday bag?
To prevent any tampering from outside sources once a cell phone is collected.
And you can put the cell phone inside a Faraday bag so it can't hit Wi-Fi, cell phone towers.
Yep, nothing.
And it prevents any tampering from outside to prevent anybody from being able to communicate with the phone.
It
from any
helps.
outside sources.
It's
Now,
a
you
tool
see-
to secure the evidence to prevent tampering.
It is
Inadvertent or intentional tampering, right?
Yes, sir, it is one tool that can be used.
Was the phone put in a Faraday bag?
And was Maggie's phone put in a Faraday bag when it was seized on the side
No,
of Moselle
no,
Road?
it was not.
No, it was not.
I could be the defense attorney right
Anyone
here,
asked?
right now.
Or
Boom!
bring up the fact.
You guys should be super chatting
Hey,
like
maybe we should get a
crazy.
Faraday
You ain't getting
bag
this
before
type,
we
this
move this
level
phone.
of.
I
Look at
did
this.
not
I'm
ask.
calling the questions before he
Anybody
even
asking you
asks them.
brothers?
Not that
This
I'm
is
aware of.
easy. I'm telling you, people, this is how you lawyer.
Now, on June 8th,
You
He's
don't
doing very
get this
good this
type
morning.
of. You
His
don't
pacing-
get this type of legal analysis.
you were
like
briefed
this.
and
His
Nowhere
pacing
else.
is
You
good.
advised that
His
Alex
pacing is good. His questions
found
are
his
good. They're
wife and
poignant. They're
son
going places.
murdered. He was the one that discovered them, correct?
And
I feel
I'm
like we're on, I
literally-
feel like
Yes,
we're on a
sir.
journey.
And on June 8th, you knew that he
And
was
Oracle over here is doing Oracle. So
Maggie's husband, Paul's
Laracle.
father.
That's
Immediate
because
family,
you litigate, David.
Yes, sir.
If I was that, I'd be killed.
And as part of your
You ain't putting no Faraday bag.
long-time experience investigating crimes, murders in particular, someone who finds the bodies and is related to the victims is always going to be
A suspect.
looked at.
No,
Is that
they're
fair?
suspects.
That
course.
would be a fair statement, sir.
And y'all were looking at Alex on the 8th. SLED was, correct?
Yes, sir.
And
This is called the.
would you have a
we found
label?
our
Was he
guy, so we look for no
person
one
of
else.
interest?
That's what you're trying to
Suspect
say.
on the
You
8th?
already found your guy, so you disregard
We were looking
any
at
other
Alex
evidence for
being
anybody
the
else.
one that found
That's what this line of
the,
questioning is to get to.
deceased.
That's
being
the
husband, the father,
the bomb that he's trying to explode.
in an attempt to get Mr. Alec out of that immediate circle.
And you've described this investigative circle. So you draw a circle around potential persons of interest, and Alex was in that circle, correct?
I
don't
gotta
draw a
go,
circle
man. I
around
gotta
any
go. I got
individual
3 minutes
person.
before I have to go.
We work with the
Can you
crime
come back
scene,
in an hour?
which is what we consider
come back
the
in an hour?
circle.
I'll try to
And
come
we
back
work
because I have
our way
my recording
inside
session for my
out,
stuff. So
in order to find any potential suspects,
could you
identify suspects, clear individuals. So we start with the small circle.
So when you started with the small circle, although you don't draw it, I mean, it's a sort of an investigative mental tool. Who was the person in the small circle?
We had Miss Maggie was in the crime scene, Paul was in the crime scene, and Alec was in the crime scene.
And you remember that on the morning of the 8th, there were media reports that Alec was a person of interest in the murder of his wife and son. Do you remember that being public knowledge?
I try to avoid the media in any investigation because I don't want to be influenced by anything that's said.
And the, what do you recall SLED putting out a press release on the morning of the 8th that the public need not be alarmed?
I do not recall any press release being put out by SLED.
Now remember, people, it doesn't matter. He's the lawyer's testifying.
Well, the point being,
there was a
on
press
the 8th,
release.
there
It
was
doesn't
a
matter what he
circle,
said, yes or
and it was
no. We
only
know there's a
around
press
Alec.
release, right?
He was the only living and breathing person in the circle. Is that correct?
That is the only person that we could place in the circle at that time.
And on the 8th, SLED knew that, from what interviews with Alec, that he said he left Moselle at shortly after 9 p.m., went to visit his mother in Alameda, stayed for a while, and came back. SLED, and you were aware of that fact?
I am aware of that, yes, sir.
Did anybody at SLED ever, on the morning of the 8th, hightail it over to Alameda and search the house for any evidence whatsoever?
I did not go to Alameda and search the house on the 8th.
Are you aware of anyone ever going to Alameda to search the house until sometime in September of 2021?
There was a number of agents out working. I'm not sure what the other agents did.
Those were bad questions. It was too broad.
Wouldn't it have been a good idea
anywhere,
to go
I
to
don't know.
Alameda on the morning of the 8th, where the guy
They
in the
could have
circle
gone. They
says
could have
it
gone.
was,
I don't
right?
know. They could have gone. That's what
I
she
did
said.
not go, and I can't testify to what other agents did.
They could have gone. I don't know.
Well, you've been working this investigation. Are you the lead case agent?
No, sir, I'm not.
Who's the lead case agent?
David Owen.
He's asking questions he doesn't know the answer to.
Every interview that Alex Murdaugh gave, you participated in, right?
I did,
Objection.
sir.
So were you working, sort of Agent Owen's right-hand man in this investigation?
I was assigned by the captain to assist Agent Owens.
That'd be a yes.
So
The right-hand
it's fair
man.
that you knew daily
He's
developments
talented,
as the investigation
characterization
progressed,
of right-hand
right?
man.
We had briefings with each other on the case. Yes, sir.
And you knew that at no point in time, in June, July, August, anyone went over to Alameda, searched the house, searched the property for any dirty clothes or any murder weapons.
Question
I
asked
know
and
that
answered. He
I
said
did
he
not
didn't know.
go.
I'd be, if I'm the prosecutor, I'm
not
jumping
sure
up.
what other
He
agents,
doesn't know. He said he doesn't know.
in
He's
the
asking about
investigative
Alameda. He doesn't know.
Well, if you went over there, if you had gone over there on the morning of the 8th, scoured the place and not find anything,
Objection.
that would
calls for
sort of help
speculation.
nudge Alec outside this investigative circle, would it not?
I can't testify to what if.
There's something
sir.
he didn't do.
I-
Yeah.
I
What
did
if
not
this?
go.
That's what the prosecutor needs to be jumping up. Calls for speculation. What if? What if? No. That's exactly what he's doing. Calls for speculation. Stop
On the
this.
8th, you were asked to point out who's that person, who's that person, who's that person. That's Ronnie Crosby. He's a lawyer. That's Mark Ball. He's a lawyer. That's Lee Cope. He's a lawyer. You remember that testimony?
I do, sir.
Now, Alec wasn't lawyering up on the 8th. Those were his friends who came over to help him. Correct?
Oh, no. Ooh.
They were given counsel to Alec as far
Oh,
as
now so was he a lawyer or were they not lawyers? They were just lawyers
what we
and
were doing.
friends.
They were making phone calls to his counsel. That was the instruction which we gave. We were given.
And they were assisting you, as you saw on the body cam, go through the evidence that you ended up seizing in the gun room, right?
They pointed out some items that
So
they
his
had
lawyers are pointing out
concerns
items?
about.
Did you find that their efforts were obstructing your investigation?
They didn't obstruct our search within that gun room, no, sir.
Now, you went back, I think, on June 13th, is that correct?
Yes, sir, we did.
And remind me, what was the purpose of the search on June 13th?
Search on June 13th was a follow-up search of the residence. I would have to see the search warrant, actual search warrant, to see what items was being sought at that time.
Are you testifying that you had to get a search warrant on the 13th?
Search warrant or consent, I'm not sure. I don't know what exactly, everything that was being looked for at that time.
Yeah, but one of the two.
In fact,
get you there.
Alex Murdaugh gave consent anytime he was asked by SLED if they could go on the property, right?
My understanding is consent was obtained each time.
And so
So why did you just say warrant?
there
He
was
just
no
tripped
search
his own
warrant
self
on
up.
the 13th, was there, Agent Crone?
I would have to see our legal.
You just said
whether
to
it
give
was
consent
or search warrant. I do not know.
Right. And you don't need a search warrant if there's consent.
No.
No, sir, you do not.
And in this interview, this search, you've seized
Morning, Kurt.
Exhibit
Thanks for your great
151,
coverage and analysis.
which
I hope you
is
go to Vegas. You deserve a break.
empty.
Always a fan, Orange
That's-
Heart.
300 blackout.
Thank you, Amanda.
Clip. Is that right?
Well, listen, Kurt,
Magazine.
this was a
300
wonderful
blackout
little morning
ammunition,
thing, but I got to go
That
do
was
some of
found
my own work and get some stuff done. So it
yes.
was
Collected
good.
from a black
Thank you,
Ford
chat.
F-150.
If you can
this
stop
is
by
going on,
at
On the property.
quarter past, that'd be
That's
helpful
correct, yes,
because
sir.
that's when I have that phone
Yeah, I
call.
think-
But if not, I
think you
hope
testified
you have a
it
great
was found
morning.
Yeah, I don't know if I can make it back before 12 because I got a lot to
didn't
do.
testify
But
where
but
it
I'll
was
try.
found.
I'll try if I can.
You
I
know
can
where
say.
it was found?
Thank
All
you,
right, you're the
Jeff,
man.
for
The black
for
Ford
staying with my
F-150.
nonsense because you know how I
find?
get.
No,
But
right.
I appreciate it. Take care.
All right, thanks for dropping by, Nate.
Now, the jury heard this videotape interview of Alec on June 10th, where he told you that Paul left everything everywhere. Do you remember hearing that statement?
I do remember that, yes, sir.
And does this evidence support what Alec told you, that Paul left everything everywhere if you found a clip, 300 blackout?
I can't testify to who had the magazine in the F-150.
Do I think this is
Do you
useful?
know who last
Hell
drove
yes.
that F-150?
I do not, sir.
I think the defense is kicking ass.
Was any analysis done of that clip?
The way it's packaged there, it does not appear that there's been any analysis done.
Were any fingerprints taken of that clip?
Again, sir, the way it's packaged, it does not appear that there was any analysis done.
Did the courtroom audio drop?
And
I think it did a little bit,
there was
actually.
another, clip that was seized from the shelf in the gun room. I don't have that pulled up, but I think it's 150 perhaps. Did you remember seizing another clip from the gun room?
Yes, sir, there was another magazine with 300 blackout.
And any fingerprints taken from the clip seized from the shelf in the gun room?
I don't think so, sir.
Was there any analysis done of the clip taken from the shelf in the gun room?
The way I recall it being packaged yesterday, it would appear that there was no analysis performed.
Yet you brought it to court. You want this jury to have it. Why is that?
Basis for the objection.
I believe that's outside the scope of this witness's purpose here as to why it's being offered in court.
Response to the objection.
You're not asking his knowledge, not anything beyond his knowledge. He could say, I don't know, or if he has a reason.
Overruled objection.
Can you repeat the question,
Yeah.
please, sir?
Do you know why you were asked to bring those clips here to court and put them in evidence before this jury?
I do not, sir.
Now, you also did a search of the shooting range, and I couldn't go through my notes, and I can't I don't have a date. Was that on the 13th or a different day?
I'm not sure if it's the 13th or the 16th.
16th? I think you may be right. Either way, again, that was a consent search, right? You didn't have a search warrant for that.
We did get consent for that, yes, sir.
And the jury saw the video. We're not going to belabor that again, but there was a shooting house, if you will, with a chair and a thing you would rest a gun on. And we saw you picking up a lot of shell casings, right?
Yes, sir.
And the shell casings you were picking up were the 300 blackout spent shell casings, cartridges, right?
That is correct, sir.
But there was a lot of brass in there that were not 300 blackout cartridges, right?
There was additional brass that was not 300, yes, sir.
Now, we didn't get a good look. If you're sitting in that chair in that shooting house, downrange, do you remember what was on the other end of 100 yards or so away? Do you remember what was on the other end?
I do not recall what's back on that end, no, sir. Target.
Thank you, Night Eyes, for the gift memberships.
Are you aware there's a big dirt mound there?
A berm, too.
Yeah. That's safe, right? You don't want to be shooting a rifle just going down without something to stop it. So there's a berm there to stop it.
It was going into a wooded area, yes, sir.
But there was a
dirt mound. There was a dirt mound.
There was a target and then a dirt mound behind it.
That's correct.
Now, we saw you picking up brass. Who went down to the other end and started digging in that earthen dirt mound to find fired projectiles?
I did not go down to the other end, no, sir.
In fact, nobody at SLED went to that other end to dig out 300 blackout fired projectiles, did they?
I did not, and I don't know what the other agents did, no, sir.
Oh, dear.
When you're assisting Agent Owen, you're going to briefings. You didn't hear at any point in time while we should have or we did dig out projectiles from the dirt mound.
I never heard of anyone digging out the dirt mound.
We never tried to dig out rounds from the dirt mound
If you had
to
dug
match
out
the
projectiles from dirt mound,
ballistics to
that could have
rounds
been
that were
sent
used during the
to
shooting.
the ballistics lab
Great.
at SLED
That's just great. Good work.
and done a comparison.
That's just really great
Projectiles
work.
found at the crime scene.
We never
There
bothered
would
to
be a lot of
search
elements that
the
would
dirt
go
barrier
into
designed to
whether
catch
it could
blood
actually be looked at or
for
not.
spent rounds that we then could
We
match
certainly
the ballistics,
compared
the rounds
to
used during the murder. That's
what
just
was-
really great. Good,
I mean,
good
you
work,
take
SLED.
it.
That's fantastic.
300 blackout, shoot it out of Buster's gun right there leaning next to you and compare it to the projectiles. You're aware that could be done at SLED, right?
Yes, sir, I am.
But it wasn't, was it?
I'm not sure what testing was done on this particular rifle to compare it to anything at the scene.
Okay. Now, let's go to the June 10th interview. You and Agent Owens interviewed Alec in Agent Owens' SUV, SLED issued vehicle on June 10th, right?
Yes, sir, we did.
And that was at Brother John Marvin's hunting lodge in Barnville or somewhere close by, right?
Yes, sir.
Not yet, though, not yet. A lot of people were interviewed that day, right?
There was a number of interviews going on at the same time, yes, sir.
And that was consent, correct? The interviews were consensual.
Yes, sir.
And you interviewed, the folks being interviewed that day not only included Alec, but they included John Marvin, his brother, his son Buster, and his other brother Randy. Is that correct?
To my recollection, yes, sir.
And
Murdaugh's over here consenting to everything.
When
He's
you
giving you
pulled up-
permission to search everything,
on June the 10th,
which you then don't do.
it's about,
Lol.
was it early afternoon it seemed
He's
like?
giving you the password to the phone.
The timestamp should be.
He's
on the
talking
video. I
to
don't
you.
recall
He's giving
what
you
time
his
it was.
DNA.
But it was a little bit like the cavalry coming, wasn't it? Because there were a lot of cars that pulled up at one time, right?
They were aware we were coming.
They were. How many agents went?
We took agents to interview each person that was there.
You took 2 agents for each interview, right?
I think there was 2 agents for each interview, yes, sir.
And each agent came in their own car, right?
I think I may have rode with Special Agent Owen. I'm not sure if the others drove their own cars or not.
Well, and so there's at least 4, could have been more than that, cars, right?
There was probably full cars, yes, sir.
And you put each person, Randy, John Marvin, Buster, and Alec, in a separate car all at one time.
Pretty close to the same time, yes, sir. Each one got in a car with agents.
And that's a law enforcement investigative technique so that you don't want witnesses to be comparing notes, and you want to interview them in separate places, same time, and to get what's fresh on their mind without learning of what another witness has said, right?
We wanted to interview them individually, yes, sir.
And you said they knew that they were coming, but did you alert anyone that we're all going to be coming in, at least 4 cars, and we're going to interview you separately at the same time?
There was some other things that was going to take place while we were conducting the interviews, so it was arranged that they would all be at that location, and we were going to meet them there and conduct the interviews.
Yeah,
You also had
that's
a guy
Sled's
there
reputation.
to,
Sled
Sled
has a reputation
Yes, sir,
for
those
being
are those
gung
things
ho,
I'm talking
brazen,
that
entitled,
wasn't-
and sloppy.
told to Alec or John Marvin or Buster or Randy before Sled rolled in on the 8th at John Marvin's hunting lodge, right?
It's my understanding that they knew we were coming and that we were going to request.
So if it makes anyone
the,
feel better,
phone
this may not
analysis
be special
done.
treatment.
You think
Lol.
someone, when Sled would have told
So there's the good
Alec
news.
ahead of time?
It
told
may
John
not be
Marvin ahead
because
of time?
of privilege or
Yeah,
special
we're
treatment.
going- when we
This is
get
just
there,
kind of paranormal.
Be sure not
So-
to erase anything off your phone because we're going to download it.
I didn't set the meeting up. I went with Agent Owen to conduct the interview.
So, but one of the first things you did in the interview was you and Agent Owen was ask Alec if he would give over his phone so that it could be extracted, correct?
That was one of the first things we asked for.
And that extraction was done, by another agent who came in a separate vehicle, I assume. Is that right?
He's not an agent with the South Carolina Law Enforcement Division, no, sir.
Okay. He was investigated with 14th Circuit Solicitor's Office,
That's my understanding of his job title, yes, sir.
and that would be Investigator Hightower. Is that who did that?
That is my understanding, yes, sir.
And during the interview, you also, at the end of the interview, you got a buccal swab from Alec, right?
I did, sir.
And you got a buccal swab from, not you, but everybody who was interviewed gave buccal swabs, meaning John Marvin, Randy, Buster, and Alec, correct?
I know that Alec, we secured a buckle from Alec. I'm pretty sure that there was one collected from Buster. I'm not sure about John Marvin and Randy.
Now, yesterday, we listened to the entire video interview with Alec, and it ran for almost an hour, could have been longer, but you sat on the stand and heard that, right?
Yes, sir, I did.
And at various points in time, you were asked, what did he just tell you? Did he just tell you this? Do you remember that?
I do, sir.
And then you get to one point in the interview where you're asked, what did he just say after you said it must be tormenting? And you testified that Alex said on the video captured by audio that it was so bad, I did him so bad. That's what you testified to yesterday.
Yes, sir, that is what I testified to.
Now, are you 100% confident that Alex said I did him so bad rather than they did him so bad?
I'm 100% confident in what I heard and I interpreted him as saying.
But you would agree that this jury can hear the same thing you heard on June the 10th by playing what was captured on the body cam or the recording equipment in Agent Owen's car, right?
Yes, sir.
Now, when you heard what you said, you're confident what you heard, that he said, I did him so bad, what'd you do in response to that?
Thank you, Amelia. I spent some.
I made a mental note on it.
I spent some
of it.
time trying to
Again,
get the
we were
color
still
scheme
in the
right on
early
my background
stages
today, so
of
I'm glad you like it.
investigation. It was more of an information gathering from Mr. Alec, and we did not have information at that point, to my opinion, to challenge Mr. Alec on any of his statements.
Your Honor, let me. So, Alex Murdaugh
Just wait.
was the one and only in this circle on June the 10th. You're in the car with him, and according to your testimony, he says, I did him so bad.
That is what I understood him to say, yes, sir.
And yet, you just said you took a mental note of it.
Yes, sir, I did.
I mean, if the guy in the middle of the circle, the only one in the circle, says, I did him so bad, isn't that a significant statement if he actually said that?
It's definitely something we would follow up with.
I bet you
never
would.
followed up with it, did you?
There was a third interview conducted with Mr. Alex.
There was a third interview. There was a third interview conducted on August the 11th, 2021, right?
I don't recall the exact date.
We hear about it, but you were there, right?
Yes, sir, I was.
Tell the jury
Thank
if
you,
you
Tammy.
asked Alex Murdaugh on August 11th,
Gift
2021, what did you mean back on June 10th when you said, I did him so bad?
We didn't make it to that point, sir.
We didn't make it to that point. So let me get this straight. It was really, really significant. It's something we wanted to follow up on.
Back on
We did
June
have a
10th,
follow-up interview.
after
We didn't
you
follow
had
up on it.
this,
That's what he just
what-
said.
What you heard
Fantastic.
him say, I did
It's
him so
something really
bad.
notable. He's at the,
You went
he's
on
in the
to
center
talk
of our
about
circle of suspicion. It's something we want to follow up on. We had a follow-up
Funeral
interview. We didn't bother
arrangements,
asking.
whether they're going to be public or private. Isn't that right?
There was questions concerning funeral arrangements, yes, sir.
And Agent Owen says, well, Alex said he's trying to make arrangements so it wouldn't be, a lot of media there or any media there. And, the guy who just said, I did him so bad, the response to that was, they don't deserve to be there. You recall that?
Repeat that again, sir.
Do you recall
If you don't
Agent
mind.
Owen saying in your presence to Alec, the media did not deserve to be at Maggie and Paul's funeral?
I do recall Agent Owen saying something about the media not being there. Yes, sir.
And that was after, according to you, he said, I did him so bad.
Yes, sir.
Did you consider that to be some sort of confession on June the 10th?
Again, it was something that we were definitely going to follow up on. Yes, sir.
But you did it, though. Yeah. What was that? What were you planning on doing that? Just that raw
Getting
curiosity.
ready for your testimony yesterday,
Excuse me.
did you review a transcript that was prepared by SLED of that interview? Of
Oh,
June
my
10th with
God.
Alec?
No, sir. I have never seen a transcript that was prepared for that.
Was there a
You aware the
transcript,
transcript
and
was
does the
prepared,
transcript
sir? No,
say
sir, I'm
something
not.
else other
You
than
hearing
that?
the first time?
Yes, sir, I am.
Oh, please. Is there a
Wait a minute, back on
transcript,
June
and
10th,
does
why
it say
didn't you ask
something
him
else?
right then and there when he said, I did him so bad? Why didn't you ask him, what do you mean by that, Alec?
Again, it was early in the investigation. It was more of an information gathering interview, if you would call it an interview, with Mr. Alec. And we did not, at that particular time in the investigation, we did not have evidence to challenge anything that Mr. Alec would have told us. It was decided that we would not. crossed that at that time.
I mean, my question wasn't, why didn't you challenge him? My question is, why didn't you ask for clarification? Like, what are you talking about? You did him so bad.
Asking for clarification of I did him so bad would ultimately be a challenge of what he said.
Okay.
So what were the things going through your mind when you heard or misheard, I did him so bad? I mean, like, I wasn't a good dad? I spoiled him? Or I killed him? I mean, what was going through your mental note?
Now he's providing some possibilities of what that could mean, right? Assuming it is, I did him so bad. Here's some things it could mean. He's putting that in the mind of the jury, right? Here's some more innocent explanations.
From the video, it appears you're back there taking some notes.
I like it. Subtle.
Yes.
I like it. Subtle. Priming. Good job.
You mentioned you made a mental note of this, what you heard or misheard, I did him so bad, but did you make a written note of him saying that?
I don't recall if I wrote it or not, sir.
So it's possible that you're sitting there with a guy who's now been charged with murder on June 10th in the interview, the father, the only one in the circle, and he says, I did him so bad, and you can't tell the jury you even wrote it down on a piece of paper.
I don't recall if I actually made a physical note of it or not, sir.
Hmm.
I'm going to play that clip from State's Exhibit 243, which is in evidence. I want you to listen again with the jury. Hang on, y'all.
Okay, so we're going to listen to this again. Now that we've primed the jury for the idea of it could be they, and we've primed the jury for the concept of what else he could be referring to if he said I. All right. Well, now that we've primed the jury for that, let's give us another go. This will be fun.
All right, let's play it. Please, Doug. Exhibit 243 in evidence.
It's tough. It's just so bad. They did it so bad.
All right. Back it up and play it in real time again, Doug. Real time.
Or not easy. I know it's hard. And sitting here talking today is tough. It's just so bad. They did it so bad.
I can't tell.
Did you hear now, they or I?
I will still testify that my hearing, I hear I.
We'd like to play it again at 1/3 speed to slow it down. It's just the same. Thank you.
Playing it at 1/3 speed. There's no foundation laid for who's manipulating it, how it's being manipulated. I think obviously we have it in real time, but there would have to be some additional foundation.
Overruled. Deal.
Play at 1/3 speed.
And sitting here talking today is tough. It's just so bad. They did it so bad.
I have to tell you, between the two, I'm hearing they, guys. I hear they. I'm saying that's what I'm hearing.
Did you hear they then?
No, sir, I did not.
Okay.
Uh-huh. Sure you didn't. Okay, fine.
But you would agree the jury gets to decide what he said on that tape. That's the best evidence.
I agree that they get to hear the tape and make their own mind up as to what he said. Yes, sir.
There you go. Jury, you're the finder of
Thank you.
fact.
That's all I have on that.
Right? That's what you need to say. Jury, you're the finder of fact.
Now,
You get to decide what it means.
I said the
not this
date August
expert.
11th. You said you weren't sure.
Good work.
But there
Good
was another
counselor.
interview with Alex Murdaugh came to the SLED Low Country office.
So, as a matter of fact,
You and
what does it say?
Page no one
I or they?
sat down and
You
interviewed
get to decide.
him, correct?
That is correct.
Now,
Not this guy from SLED.
On all these interviews that were conducted and that have been played somewhat, or body cam conversations, except for Ella, when you're doing them, do you tell the person that you're interviewing, hey, I'm going to turn the audio recorder on, you're now being recorded? Is that standard operating procedure?
We normally don't advise that we're recording, no, sir.
Okay. And you certainly didn't advise Alec that you're recording him on any of the interviews that you conducted with Agent Owen, correct?
I never advised anyone that I was that they were being recorded.
And this meeting that you had, were you aware that Alec was asking for the meeting so that he could get an update on whether you made any progress in the investigation of the murder of his wife and son?
I was aware that Alec had requested a meeting to raise some questions as to what was going on.
I mean, he wanted information as to what was going on, right?
That's my understanding, yes, sir.
But y'all had other plans for that meeting, correct?
No, sir, I'm not going to say we had other plans for that meeting. It was an interview.
Yeah, I mean, he came there he didn't go to that meeting thinking, I'm going to be interviewed, to your knowledge, did he?
To my knowledge, I don't know what his thinking was. He knew he was coming there to meet with myself and Agent Owen.
Okay. And during that interview, pretty much you made it known to him that, well, I mean, you asked him point blank, did you kill your wife and son?
He was asked that.
And you made it pretty clear that, well, let me ask you, at that point in time, was he full bore suspect in your murder investigation?
He was still a person of interest. There was some questions that we had regarding information that we had obtained that only he could answer.
And did he answer the questions that you asked?
Yes, sir.
And then at the end of that interview, he asked you to meet with Maggie's mom and dad, Mr. and Ms. Brandstetter, and her family, correct?
I think that was the end of the second interview, not the third interview.
All right. Well, shortly after that, shortly after that third interview with Alec, which we'll get the date in the record eventually, a few days later, you and Agent Owen went and met with Maggie's mom and dad, and sister and brother-in-law, and nieces, correct?
That is correct.
And part of that interview, that interview was recorded, right?
The interview with
the
Brandstetters? Yes, sir. It was audio recorded.
Did you tell them you were recording it?
We did not.
And
I don't think. I did not tell them.
And part of the interview was conducted as part of your investigation to get information to assist you in next steps, correct?
Mark asked about the grand jury. Remember, a grand jury only has to find probable cause.
And also to gather information concerning family dynamics.
There's probable cause.
In that interview, you and or
but there's a lot of space between probable cause and proof beyond a reasonable doubt.
That Alec is in the circle of investigation.
The grand jury isn't necessarily wrong to return an indictment, but
in that circle at that point, no, sir.
There's a lot of space, and right now we are not making.
He's the only one that you've identified in the circle, correct?
I don't recall saying he's the only one in that circle.
Well, did you identify for the Brandstetters or the Proctors any other people in the circle?
They particularly asked about Alex, so I don't recall giving them any other names that was being looked at.
In early August of 2021, was there anybody else in the circle that your SLED was focused on?
Again, sir, at that particular date, I'm not sure who all was still within that circle.
And during this interview, Maggie's mother, Ms. Kennedy Brandstetter, her father, Mr. Terry Brandstetter, her sister, Marion Proctor, and brother-in-law, Bart, and their children described for y'all their observations of Alex's relationship with Maggie and Paul, correct?
From their observation of their relationship, yes, sir.
And that was, you were asking that as part of your investigative tool and getting
Yes, sir,
information.
that's correct.
And they reported to you that Alex had a loving relationship with Maggie and Paul, correct?
Rule 801 and 802.
Pardon?
Objection, Rule 801 and 802.
Response.
It's not being offered for the matter asserted, Your Honors, what he did in response to that.
Objection sustained.
Rephrase.
Were you given information in that interview? Did they identify other people who had warned Maggie that word on the street in Hampton that there was some risk to her family's safety resulting from the boating accident?
I don't recall any specific information concerning warning of threats or of any nature. No, sir, I don't.
Well,
I
the
don't
defense
recall that.
certainly put it in the jury's mind, which,
You don't
you know.
recall being provided the name Barbara Mixon?
I do recall being provided names of those that may have information, but as far as specific information, I do not recall any specific information that was shared by the Branstetters.
You know whether Ms. Mixon was ever interviewed following your meeting with the Branstetters?
I know I never interviewed Ms. Mixon.
Were you given information about Ms. Keena Traherne of a similar nature?
Again, I never interviewed Ms. Traherne, if her name was given, no, sir.
1 minute, Your Honor, may I check to see what I left?
If Maggie was seeking a divorce, it certainly hasn't been proffered in this trial yet. So, I know there was some rumor of that, but I'm not sure that that's actually true. And it certainly hasn't been brought into the trial yet, so. Why is the defense not playing the interview? Well, they don't necessarily need to. Right, because they don't need to play the interview for the purposes that they're trying to talk about it. It's like, you thought this was really important, you wanted to follow up on it, you didn't follow up on it. So it's not, what they're asking about isn't on the tape, so you know, there's no real. Okay.
Thank you, Your Honor.
That was pretty effective cross-examination.
Senior Special Agent Croft, a couple things. When you went back, or you went and searched that house, your focus was searching for guns. Is that correct?
That is correct, sir.
And to your knowledge, when other agents walked through the house with the family members, and this is on June 8th, fundamentally they were looking for firearms. Is that correct?
That is my understanding, yes, sir.
You were asked about these weapons that you seized that are put into evidence, and you were looking for any particular weapon that could fire rounds consistent with those that were used at the scene. Is that right?
That is correct.
I'm on redirect, Your Honor.
It doesn't matter. You cannot lead. Did the judge just say you can lead the witness?
What is the point of gathering as much evidence as you can when you have that opportunity? What are you trying to do there?
We were trying to gather as much evidence that could be tested as potential weapons for the scene to be able to include or to exclude Mr. Alex or these weapons from being the person responsible for the murders.
You were asked a little bit about this right here, and this was June of 2021, correct?
That is correct, yes, sir.
Had COVID had any effect generally on the availability of ammunition?
I'm sorry?
Had COVID had any effect generally on the availability of ammunition?
Yes, sir.
And tell the jury what, if any, effect that was.
Ammunition was difficult to get during that time because of the shutdowns during COVID.
Did you find a lot of ammunition inside the defendant's residence?
There was quite a bit of ammunition.
Did you
inside.
find a lot of different types of ammunition inside the defendant's residence?
Yes, sir, we did.
Did you find a lot of S&B 300 blackout in the defendant's residence?
That was mostly what we found.
You were asked about the commonality of various rounds, blackout through others, and you mentioned .308, 223 and 556. Can you tell the jury a little bit about those rounds and why they tend to be a bit more common as you testified to, please?
I'm sorry, can you mind repeating?
Yeah, sure. You testified.
Objects beyond the scope. I didn't ask anything about 223s and whatever he said.
He asked about the commonality of blackout, and he answered about those
The
other
witness
calibers.
asked you to repeat the question. I would like to hear it as well.
Yes, sir. You were asked earlier about the commonality of blackout, and you mentioned it was not as common as 308, 223, and 556. I was asking you to explain a little bit about those calibers and why they are more common.
223 is a very common round. It's utilized in law enforcement. 556 is utilized within law enforcement and also within the military. It's prior to COVID, it was easily found, fairly cheap ammunition to go out and shoot as far as rifle ammunition goes. 308 is a hunting rifle, which can be used for larger game such as whitetail and stuff like that. 308 is also a common round that's used within the law enforcement and the military side. It's a very common round. 300, on the other hand, it's just at that particular time, 300 rounds or weapons were just not that common.
How many criminal investigations have you worked where 300 blackout was the murder round?
I have none.
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 You were asked earlier about the boxes and what has been admitted into evidence as states 214. And are there multiple exhibits in that particular bag that was not opened?
Yes, sir, it is.
Right. And aside from the boxes, what, if any, other exhibit is in that particular bag?
It is what appears to be a credit card receipt with one particular item circled.
And that item circled was what?
Gucci.
He's learned his pronunciation since yesterday. He's very happy with himself.
Of course, the dog's swimming out here.
How's Gucci relevant? I don't know. If the fact it's Gucci is relevant, it certainly hasn't come up yet. We found a receipt. There was on one item circled. It was Gucci. It was for something like $1,200 or something like that. Why that information is important in any way, I have no clue. I suppose we're trying to insinuate, like, we were mad about the purchase of the Gucci and we killed her because of the Gucci purchase, I guess. I don't know. But I have no clue why the Gucci matters.
You were asked a few questions about the...
all I know
what
for
the lab
sure is that
report
they
found.
didn't go to with Dolce and Gabbana, and for that they should go to hell.
In general firearms knowledge, is that correct?
That is correct, yes,
Are
sir.
you a firearm marks and tool mark examiner?
No, sir, I'm not.
Is it your role to do that specific analysis?
It is not, sir.
Is that analysis for others to do?
That is correct, sir.
Others who will testify later?
That is correct, sir.
You were asked a number of questions about the various loads in some of these shotguns. Did you find weapons that had mixed loads, that had different types of ammunition in them?
Yes, sir, I did.
You were asked a couple of questions about the board that Mr. Harpootlian put into evidence yesterday. You recall those?
Yes, sir, I do.
Are you aware that both victims had stippling on them from their gunshot injuries?
Yes, sir, I am.
And what is stippling?
Stippling is a powder burn pattern which is left on an individual due to a close range shot.
To a close range shot?
That is correct.
Thank you. You were asked some questions about the location of where shell casings land when they're ejected out of the weapon. Is that correct?
Yes, sir, I was.
Are there a number of factors that go into where a shell casing might actually land?
Yes, sir, it is.
Can people move?
I'm sorry, sir?
Do people move?
People can move, yes, sir.
Wow. That's
You were asked
great.
a couple questions about the cell phone and whether or not it was put in the Faraday bag. Do you know if that phone was put in airplane mode?
I think it was, yes, sir.
You've been asked a number of questions about the defendant and the investigation. Do you recall during the course of the interview on June 10th, did Agent Owen mention that y'all had talked to 100 people at that point?
I do, yes, sir.
All right. And was the investigation just focused on Alex Murdaugh, or was it focused on anyone and everyone it could focus on?
It was absolutely not just focused on Alex Murdaugh.
That's not really what you said earlier. At least that's not the way I heard
in
it.
that particular interview, did Agent Owen mention victim advocates or any sort of grief counseling to Alex Murdaugh? Is that correct?
Yes, sir, he did.
When you're that early in an interview and you are interviewing someone who might be in the circle, as Mr. Griffin describes it, are you trying to keep your ears open?
Yes, sir, I am.
Are you trying to keep the lines of communication open?
Yes, sir, I am.
Are you going to confront somebody that early on, or are you going to try to keep the dialogue going?
Action leading, Your Honor.
Don't lead the witness.
What is your goal when you're that early in an investigation and interviewing witnesses
don't lead
or
the
potential
witness.
subjects?
Okay.
Again, based on what we had in
That's
this
like-
particular case.
I'm
the
glad I
interviews
misheard,
conducted
because I would have
with
been real
Mr. Allen would
surprised
go
if
over
they allowed
information
cross
gathering
or
type
allow
of
leading on
interview.
redirect.
It wasn't of an interrogation.
That's not how that.
about
That's not how you roll.
You were asked about whether or not anyone dug some potential projectiles out of a mound of dirt.
This better be good.
Were you aware that there were 300 blackout cases found around Maggie's body at the scene?
Yes, I was.
And what was your goal as finding similar evidence in other parts of the property?
Similar casings to the shell casings that were located at Miss Maggie's body.
Did you know that casings can be compared to casings which had been recovered already at the murder scene?
Yes, sir, I did.
So it wasn't important for you to look for matching spent bullets. What?
Did you find cases outside of the sidewalk?
What are you talking about?
Yes, sir, I did.
300 blackout cases?
Yes, sir, I did.
Did you find 300 blackout cases?
So you
around
found
across the
matching
street?
casings, and you
Yes, sir,
didn't
I
think to
did.
look for matching rounds. Is that what we're doing now? Yeah, we found matching casings at the gun range with the dirt pile that catches rounds, and we found the matching casings, and it didn't occur to us to go look for matching rounds.
You were asked about
Yeah.
interviewing a number of witnesses on that day on June the 10th. Is that right?
Yes, sir.
Is it common standard operating procedure to interview witnesses separately?
Yes, sir.
Is there anything different or unusual about that being done?
No, sir, it's not.
Would you do that in any case?
Yes, sir, I would.
The June 10th interview with Alex Murdaugh, who all was in that car?
It was myself, Senior Special Agent David Owen, Mr. Alex Murdaugh, and counsel.
Jim Griffin was there.
That is correct.
His lawyer was there.
That is correct.
Remind the jury what Alex Murdaugh did.
I'm not
for a
sure his
living.
lawyer, strictly
He was a
speaking,
trial
was
lawyer
there.
and
He
a
was
prosecutor for the Fort
present.
Worth
Well,
Solicitor's Office.
his body was, yeah.
Was that
okay.
interview aggressive in any way?
Not at all, sir.
A man matching his attorney's description was in the car, but I'm not sure he was there at the time.
You asked a number of questions about various firearms evidence that was seized in this particular case. Is that correct?
Yes, sir, that is correct.
Did you personally seize every single piece of evidence, firearms-related evidence in this case?
Not personally, no, sir.
And describe just generally what the SOP is. When you have multiple agents working a scene and they find evidence, what do they do with it?
Tag it and tag
We
it?
generally will mark it or locate it, and then one particular person actually does the collection to package and make sure that it gets to our lab.
All right. And there could be multiple individuals doing that collection?
Yes, sir.
And then where does it go from there? What happens to sync it all back together?
It's generally packaged, turn over to our crime scene or an analyst at our lab. Chain of custody is provided to track that particular piece of evidence as to where it went.
Are efforts made by those collecting it to avoid tampering with the evidence?
Absolutely.
Is the evidence collected in a manner to preserve it as much as possible in its form?
Yes, sir.
Is that standard operating procedure for all of SLED?
Yes, sir.
May I have 1 minute to locate an exhibit that's in evidence?
Yes. So I'll stand for a moment.
Yeah. We found spent casings at the murder scene.
What you looking for, Craig?
And we found spent casings that were the same casings at the shooting range. And we saw a big dirt pile that is obviously used to catch rounds. And we didn't think to look for the spent rounds in the big dirt pile to match. That would have been way too much. But we have the spent casings, so that's good. During the interview, I totes heard I did it. I totes heard Alex Murdaugh say I did it. And that was really important information to me that I obviously wanted to follow up on. But I didn't ask any questions about it during that interview. And I didn't write it down. And then we had a subsequent interview, and I didn't ask any questions about it then either. Ugh. Ugh. Oh, SLED, you're endlessly fun. Bojangles? Bojangles is a chicken restaurant and a very good one. He was in the center of our circle. He was the center of our circle, the only living person in our circle. But we weren't focused on him in any way. We were looking for all kinds of suspects, even though he was the center of our circle. Okay, great. That's fine. Thank you, Kate. Appreciate your support. I wonder if Maggie was wearing a Gucci item. Well, the receipt would roughly date the garbage to the extent we care. I'm not sure we necessarily need the receipt to date the garbage, but okay. I mean, yeah. Hopefully it'll be important at some point, because right now I'm not sure why.
Plug those out the bottom. All right, I'm going to show you what's been marked as Exhibit 145 in the evidence. And can you publish what the crime scene notes reflect about where that was recovered?
It's one unfired shot shell from a state box on bookshelf in gun room, head stamped Winchester 12 gauge.
Can I ask you to take these scissors
and carefully cut that open, please. Could I have the Elmo up, please, if I could as well? The Elmo, please. All right. Tell me, can you describe that, what that is to the jury, please?
It's a 12-gauge shotgun shell, head stamp, Winchester 12-gauge.
All right. And does the plastic part of the shell have any identifying information?
It's got dry lock, 3-inch, number 2.
All right. Can I hold that real quick? Is this what the round you were just seeing?
Yes, sir. It appears to be, yes, sir. That's it glares on it. You can't hardly see it.
All right. Can you put that back in that bag for me, please? All right, I'm going to hand you what's been marked and entered into evidence of States 149. And if you could, first of all, publish again what the crime scene notes say about that particular round.
Just one unfired shot shell from a state box on bookshelf in gun room, head stamped Winchester 12-gauge.
All right, and if you could, please, again, carefully open that bag and pull out what's inside and describe it for the jury, please.
So black in color, Winchester 12-gauge. On the side, the writing is dry lock, 3-inch, number 2.
This is the unfired 12-gauge shell that you were just describing?
Yes, sir, it is.
You could have a gun that shoots both. If you have a gun that shoots magnum loads, which are the longer rounds, they'll shoot the shorter rounds. Not the other way around, but you know.
All right. And again, what's written on this particular round?
Dry lock, 3-inch, number 2.
If you could return that to that packaging, please, and let's do the next one.
3-inch refers to the length. Number 2 refers to the shot size. Number 2 is a fairly large shot size.
I'll hand you what's been marked as State's Exhibit 146.
You would use
Again,
it
if
for
you could
like
tell us
large
what the
bird.
Crime scene
Not
notes
large
say
enough
on
for
that,
like deer,
please.
but large bird.
One unfired shot shell from Kent box on bookshelf in gun room, head stamp Winchester 12-gauge.
All right, and if you could, again, carefully open that and
2 inches length.
see what's inside and describe it for the jury, please.
12 gauges girth. Yeah, the gauge refers to the width. Gauge is width.
It's a 12-gauge shotgun shell, Winchester head stamp, dry lock, 3-inch, number 2.
Yeah, so 12 gauge is the
Same as
width.
the previous two?
3
Yes,
inches
sir,
the
it is.
length.
Can I hold it?
Number 2 is the shot size.
All right. If you'll put that one back for me. Do the fourth verse. Again, if you'd sort of publish those crime scene notes. And,
Just a note of fair warning.
follow the same procedure.
In a moment, I'm
One
about to get a phone
unfired
call that
shot
I'm going to
shell
have to take, so
from
I'm going to have to step
nightstand
off the
in
screen.
Paul's room, head stamp.
So you'll be
Winchester
deprived of my
12-gauge.
presence for a while. So, you know, brace yourselves.
All right. Tell me what, describe it to the jury.
Head stamp Winchester 12-gauge. On the side, it's got writing dry lock, 3-inch, number 2s.
All right.
And I don't know what dry lock means.
Same thing?
Yes, sir.
Unless it's just a random brand name. Is dry lock a technical designation or is it a brand name thing? I'm sure someone in chat will inform me.
All right, let's move on to the next one. I'm going to show you what's been marked as Exhibit 150 into evidence. State's Exhibit 150. And again, if you can, as best you can, tell the jury the crime scene notes on that exhibit.
It's one, and I can read shell head stamp 12 gauge found from red bin on workshop bench. The state's exhibit tag is over the writing.
Gotcha. On workshop bench, correct?
Yes, sir.
All right, if you would.
It's for duck hunting without wetting your ammo?
To the jury, please.
Is that like a major concern, wetting your ammo? If you're not keeping your ammo dry, like,
So
what?
red in color, federal 12 gauge shotgun shell. On the side is federal premium double aught buck 3-inch mag, 76 millimeter maximum, 1050 bar.
Federal buckshot?
Federal buckshot, yes, sir.
All right. Can I see that?
Yes, sir.
This was found where?
On the workbench from the red.
Means the shell
red
is
bin
sealed?
on the workbench.
they're unsealed shells? That's
Can't tell
where
if
I'm
that
kind
helps
of
or not.
confused.
Let me try it.
You can't read it on there, sir.
Why would... I don't understand. They aren't waterproof standard anyway? Okay.
All right, if you could secure that back.
All right. I've never run into this problem. I don't know why this would be a problem. But I guess there's some scenario where it would be a problem.
State's 144.
But okay.
Let's do the same procedure. If you could tell the jury what the crime
Hunting in the
notes
rain?
on that particular exhibit reflect.
Okay.
One unfired
Fine.
shot shell head stamp 12 gauge federal from red bin on workshop bench.
And if you could carefully open
Okay,
it and
fair
describe
enough.
to the
So
jury
we're
what you found.
so we need the waterproof stuff to be able to hunt in the rain. Okay. All right, I
It's,
guess.
Red in color federal 12 gauge. Writing on the side is federal premium double aught buckshot double aught buck 3-inch magnum.
All right. If you could secure that back
In
for
a
me,
boat?
please.
So you're concerned about water spray from the boat or something? Okay.
I'll show you what's been marked as
I've
State's
I've
Exhibit
obviously never
143
hunted
in
this,
that
so I don't know.
particular
All right, I gotta step off my call, guys. I'll talk to you guys later. I'm stepping off.
If you could read what the crime scene notes say.
One unfired shot shell head stamp 12 gauge federal from red bin on workshop bench.
All right. Again, carefully open it and describe to the jury what's inside.
It's red in color, 12 gauge federal shotgun shell, stamped on the side, federal premium double aught buck 3-inch magnum.
Same thing as that previous two?
Yes, sir, it is.
Federal buckshot, correct?
That is correct.
All right, if you could put that back for me. And we'll do one more. Got State's Exhibit 148. If you could, again, tell the jury what the crime scene notes reflect about its location, please.
Says one unfired shot shell head stamp 12 gauge federal from red bin on workshop bench.
All right, if you could, carefully open it and tell the jury what's inside.
It's a red in color, Federal 12 gauge shotgun shell. On the side writing is Federal Premium, double aught buck, 3-inch mag.
Same as the previous three, is that correct?
That is correct, sir.
All right. 4 draw locks?
Yes, sir.
4 buckshot?
Yes, sir.
The draw locks are what? Brand?
They're black in color. They are Winchester,
And the buckshots are what?
Federal.
Just got a couple more questions for you. You were asked whether or not you took down any notes at any point in the interview or at a particular point in the interview.
Yes, sir.
The interview is being recorded, is that correct?
That is correct, sir.
Was Alex Murdaugh in custody at that interview?
He was not, sir.
Was that interview voluntary?
It was, sir.
Was that interview aggressive?
It was not, sir.
Was his lawyer present?
His attorney was present, sir.
And he's a lawyer too, or
Yes.
was a lawyer?
Yes, sir.
Further recross.
Just very briefly, Your Honor. Agent Croft, you mentioned stippling with regard to the injuries of Maggie. Do you know how many bullet wounds she had that had stippling?
I know at least one bullet wound had stippling. Yes,
Just
sir.
one. That's all you remember?
Yes, sir.
All right. And then talking about on the June 10th, y'all had interviewed 100 people or more, broad investigation, but did you have anybody else in the circle on June 10th besides Alex Murdaugh?
We had names of interest that we were interviewing. Yes, sir.
And then you were asked about projectiles versus shell cartridges. Are you aware that projectiles were found? 300 blackout projectiles were found in the dog house and the dog bed?
I am aware of that now. Yes, sir.
And that there's a 300 blackout projectile found in the dirt by the tire trap?
Yes, sir.
So there were projectiles that were found.
That's correct, sir.
Yet you're out of the range, you don't look for projectiles, right?
I was collecting the 300 blackout spent shell casings from the gun room, or not the gun room, I apologize, the shoot house.
Now you showed a number of shot shells, buckshot, and apparently dry lock. What date were those seized?
Looks like 9/13 of 2021.
Those were seized 3 months after the murders?
Hang on a second. 9/13/2021
Okay.
is the date that's written on it.
You got June, July, August, September. 4 months after the murders.
That's correct, sir.
And do you know whether that property had been secured during that period of time?
It had not been secured by law enforcement during that period of time.
Do you know if any of that in front of you was on the property on June 7th or before?
It was there the day we collected it. I can't answer that other question.
And I understand you didn't collect any of that, correct?
No, sir.
And you don't know where it was collected from other than what you're reading on the envelope, right? I mean, you're reading someone else's evidence description. Is that correct?
That is correct, sir.
That's all I have, Your Honor.
Thank you. You may step down.
Thanks, sir.
And we'll take a break now, of about 10 minutes or so.
And we're back. Sorry for the horror show that was me not being present, but sometimes you got to do what you got to do, right? So yeah. So sorry about all that. Sorry about all that, but it was unavoidable because people work during the day, and sometimes you got to make calls. So sorry I missed a little bit of the changing the banner thing. But obviously it didn't sit very long. And then, of course, I muted Long Crime because, well, I don't have permission for that. So sorry for the silence that you guys had to endure. But what we've heard so far from the states today, well, first of all, let's just say that the defense's cross was very effective. I thought it was very good. I liked the pacing. I liked the questions. Every question had a purpose. It was nicely done. We didn't drag on, right? Every question was asked with a purpose. He knew what the answers are. Sometimes the answers didn't matter because he was just feeding the jury things. Like, were you aware of them talking to this person? It doesn't matter if he knows or not. He just wants to feed it to the jury. Were you aware of this or were you aware of that, right? So giving things, just giving information to the jury through cross-examination. Classic tactic, well done. I thought the defense basically was hitting very, very well today on those things. And then they didn't find any guns loaded with the ammo that was used on the murder, but maybe they found ammo that was the same that was used during the murders, although I wasn't really clear about that because I'm not sure if they connected that dot. Because they started asking about rounds they found in the gun storage, but they didn't ask, at least or I didn't hear, was this the same that was used in the murder? I didn't hear that connecting question. Was I the only one that missed it? Because if I missed it, I'd like to know. But I didn't hear that sort of connecting question, right? It's like it's implied, but they never actually asked. Did they? Because that'd be good. Like, is this the same? Is this the same that was used in the murder? They never asked that connecting question. So I'm like, I'm just here with, okay, we found these rounds that were in the car, the storage, but yeah. You want to know about the Gucci? I still don't know how the Gucci is relevant. I'm not sure why it matters, but yeah. They also show they didn't bother collecting bullets to compare, which was pretty hilarious. That was good. That none of the guns they found were the murder weapon. They kind of established that. I kind of wish they had gone through them one at a time. If we're looking through for any sort of criticism of the defense, is that they blew the opportunity to ask about each gun separately because the state introduced each gun separately. So if we're giving notes to the defense, the only sort of note I would give is they asked the conclusion question, but not each individual question. So I would have asked for each individual gun. It's like, as to exhibit number 90, is this the gun? No. As to get gun number whatever, is this the gun? No. And then you ask the conclusion question. So none of the guns you found were the gun. No. Right? So that's a note. How much does it matter? Not much. It was just an opportunity that was a little bit lost to really drive home that none of the many guns found were the gun. So, yeah. They talked about spent shells found on the scene and spent shells found in the shoot house. Yeah, but did they ever ask the question if they were the same? Because that's the thing that I'm not sure. And maybe they're depending on my memory to remember, but I'm not remembering. So did they ever ask the question, like, is this the same manufacturer that was found at the scene? Is this the same length? Is it the same gauge? Is it the same gun, same round? Like, did they ever ask that connecting question? I think the answer to that question is no, which implies that the answer to the question is no, because you don't ask questions you don't want the answer to. So it implies that they're not the same, which also implies that we're just trying to inflame the jury by, well, here's some shotgun shells that are vaguely similar to the ones that were used, but not the same. They connected it without asking. Well, if the connection was lost on me a little bit, to be honest. If that was true, like they should have asked the question, at least to me. Yeah. So if you from your memory remembered that they were the same, then fine. But like, I'm just hearing a lot of details. And I'm like, okay, I'm trying to remember back in testimony. I'm like, was that the exact same thing? I remember something about dry lock. I remember that name. I remember something about dry lock, and I remember something about 12 gauge. But is it the exact same? Yeah. So there was some issues there. Also, did they announce are they done for the morning, or are they just taking a break, or what are they doing now? Because I missed that too. Does anyone know what's going on right now in this case? Help. 10-minute break, thanks. But they didn't outright say it? Why didn't they outright say it? Why didn't they outright say it? Okay. Why didn't they outright say it? If it's the exact same, because shotgun shells are a little bit easier to match in some ways because you got at least 3 ways to measure them, right? You got the gauge, which refers to how wide they are. Then you talk about inches, 2 and 3/4, 3, 3.5 is the length, right? And then you talk about the shot size, whatever that is. So there's like 3 ways to measure at least a shotgun. And so you could say, well, is this the exact same head stamp? Is this the exact same length? Is it the exact same shot? Because they recovered shot from the scene. So you would know, right? You could say, because the shot, you can measure it and be like, okay, this is what shot size it is. So is it the same? Is it the same manufacturer? Is it the same gauge? Is it the same length? Is it the same shot? That's 4 ways that you can match that. And if the answer to all 4 of those questions is yes, it's the same, well, you know, that's pretty suggestive. Because shotgun shells come in probably a more wide variety comparatively than their rifle counterparts. Like if you buy .223 ammo, you know, it only really comes in one size. It's .223. If you buy shotgun, it comes in many different sizes and also what kind of shot. You can also measure it in that way because lead and steel are very common, right? So that's a 5th way to measure whether they're the same or not. And so you can ask that question. And then you could ask the question whether or not like the gunpowder matched to any gunpowder residue that you found. Is it chemically the same? That'd be a 6th way to match it, right? So you didn't ask those questions. You didn't ask each of those questions. That's what you do, at least to my mind. That's what you do. You know, you would say, okay, here's the round. Here's the rounds we found at the scene. Here's the rounds we found. Are they the same in each of these 6 ways? You ask, is it the same manufacturer? Is it the same shot? Is it the same gauge? Is it the same length? Is it the same shot size? Are they the same? And you ask that question to connect it. Break should be over. I'm watching in the background. It is not over. So, all that good stuff. Can you match the shells to the shotgun? I don't know. I don't know the answer to that question. Technically, I don't know. I'd be a little surprised because shotgun shells are more flexible than casing for a rifle round. Like the casing for a rifle round is brass. The casing for a shotgun shell is not. It's usually like a kind of polymer plastic kind of thing. It's much more flexible. So I wouldn't know, but I would be surprised if there'd be enough unique markings on a shotgun case to say it came from a particular shotgun. But I don't know. I'm also dubious on this, incidentally, for the brass coming out of the gun. I'm dubious on that too. I don't know. I'm outside my knowledge base, so I don't know if it's possible. I would imagine that you could say that they're similar, but whether or not you could get enough markings to identify it to a particular shotgun, I'm dubious. I don't know if that's possible or not. Yeah, you might be able to exclude it. Right? You might be able to exclude it, but to say they're different, I believe. To say they're the same, I'm not so sure. Yeah. Consistent with, yeah, maybe. And then we get into what exactly does consistent with mean. How consistent is consistent, right? Shells can't be matched to shotgun. Yeah, I'm. Are there lot numbers on shells? Not on the individual shells. No, there would be on the box, but not on the shells. Lot number isn't marked on the shells. When do you think they'll demonstrate motive? I don't know. How am I doing? I'm doing good. How are you doing? I'm feeling great. Life is good. Just a quick reminder, by the way, if you haven't already retweeted the pinned comment, if you
When
could.
do you think they will start to demonstrate motive? Cuss, I feel like we should know by now. Orange heart cowboy hat face.
This is day 7 of the trial. If we're matching from the day of jury selection. That's day 7. If we're matching not from the day of jury selection, then it's day 4. Something. There are outstanding motions on motive, yeah. I don't think that the judge is going to rule on it until they try to actually present it or not. I'm killing it this week. Thanks. Heavens to Betsy. I appreciate that. That's very kind of you. Am I going back to working? I don't understand what you mean. This is my full-time job now. What are the reasons they wouldn't be able to mention financials? It's too prejudicial, basically, is the bottom line. Like, it's too prejudicial. It relates to other acts evidence, which gets into all kinds of problems under the rules of evidence, potentially. Thank you very much for saying you enjoy my stream more. I appreciate that. All right, court's coming back after a break hiatus.
You may now be seated.
Also is.
If you bring the jury, please.
Thank you very much, Heather. Appreciate that. Appreciate you for saying I'm looking healthier and happier. I'm definitely feeling that way. I don't know who's up. We haven't called them yet. I don't know.
All right. Thank you. You may call your next witness.
Thank you, Your Honor. Turn it over to Mr. Conrad. State calls Anthony Nisht.
Apparently, Anthony Nisht is the answer to your question. And your next question is, who's that? I'll get back to you. I'm looking.
Raise your right hand, left hand on the Bible. Do you affirm the testimony you about to give before in this trial shall be the truth, so help you God? I do. You and the witness stand, state your name again for the record. Spell your last name, please.
My name is Michael Anthony Knitch.
Knitch. His name is Michael.
Great, how are you?
Am I pronouncing that correctly?
Knitch.
All right. And where are you employed, sir?
Verizon Wireless.
And what are your duties there?
In this capacity, I'm a custodian of records.
All right. And so it's in its normal course of business, does Verizon keep records?
That is correct.
And does it
Where are
keep
you on the
call
witness list, Michael?
That is correct.
Just generally speaking, what kind of records does Verizon keep in relation to phone accounts and call records?
Subscriber information, cellular data, which could be telephone calls, text message, data sessions.
Okay. All right, and these have been previously shown to council. I'm going to show you what's been marked as State's Exhibit 268. And I'm going to ask you if you recognize that, sir.
I do.
And what is that?
State's Exhibit 268 is Alex Murdaugh's telephone number 803-942-1227.
Okay, and
I
have you
can't
reviewed
find
the
them on the
contents of
list.
that CD?
I have.
And what is the contents of it on that CD?
Subscriber information, cellular data information, text messages, anything related to billing purposes of Verizon Wireless.
Okay, and was that, were those records previously turned over to law enforcement?
In request to a search warrant, they were.
All right. And you've reviewed those records, correct?
I have.
After reviewing them, are those true and authentic copies of the records that are kept by Verizon?
They are.
All right. And those are related to Alex Murdaugh's Verizon account, sir?
That is correct.
With the number ending in 1227?
That is correct.
All right. At this time, State moves to enter Exhibit 268 into evidence.
No
I
objection.
must be
Your Honor.
looking past his name. I just can't
Submitted.
find it on the witness list.
I'm going to approach and hand you State's Exhibit 269. Do you recognize that, sir?
I do.
And what is that?
State's Exhibit 269, Paul, cell phone 803-842-7845.
And have you had an opportunity to review the contents of that CD?
I have.
And what is the contents of that CD?
I can't
Cellular
find it.
information, subscriber information, in response to a search warrant.
Okay. And are the contents of that CD accurate, true and accurate copies of records kept by Verizon in normal course of business?
They are.
And at this time, State would move to enter Exhibit 269 into evidence.
No objection, Your Honor.
Submitted.
And I'm going to hand you, this is Exhibit 265, so a little bit out of order. And do you recognize that, sir?
I do.
And what is that?
State's Exhibit 265, Maggie, cell phone 803-842-9041.
Have you had an opportunity to review the contents of that CD?
I have.
What are the contents of that CD?
Subscriber information, cellular data information in response to a search warrant.
All right, and that's in relation to the number associated with Paul, is that correct?
Maggie,
Oh, excuse me, yes, Maggie. And what's the last four digits of that number?
9041.
All right, and that's Exhibit 265, correct?
That is correct.
All right, and at this time, State would move to enter Exhibit 265 into evidence.
No objection, Your Honor.
I'm going to approach, and I'm going to hand you what's labeled as State's Exhibit 262. Do you recognize that, sir?
I do.
And without reading any phone number, full phone number, what is that?
State's Exhibit 262, Plod Row Records.
All right. And have you had an opportunity to review the contents of that CD?
I have.
And what are the contents of that CD?
Subscriber information, cellular data information in response to a search warrant.
All right. And those are related to the account associated with.
Thank you,
Paul
Adam,
Murdaugh.
for the gift memberships.
That is correct.
And there is a phone number associated. We're just not going to read it in the record. Is that correct?
That is correct.
At this time, and what number is that?
State's Exhibit 262.
This time, State will move to enter Exhibit 262 into evidence.
No objection.
Submitted.
I'm going to approach and hand you State's Exhibit 263. Do you recognize that, sir?
I do.
And what is that?
State's Exhibit 263, Marty Cook.
All right. And is there a phone number associated with that without reading it?
There is.
And that's a Verizon phone number, correct?
That is correct.
What are the contents of that CD?
Subscriber information, cellular data information in response to a search
And
warrant.
you've had an opportunity to review that, correct?
I have.
And those are a copy of the same records that were provided to law enforcement pursuant to a search warrant. Is that correct?
That is correct.
All right. And what number was that again?
State's Exhibit 263.
All right. This time, State will need to enter Exhibit 263 into evidence.
I'm sorry, I couldn't. Whose number is that?
State's Exhibit 263. What's the name on that account?
Marty Cook.
No objection.
Submit it.
All right. I'm going to hand you State's Exhibit 264. And do you recognize that, sir?
I do.
And what is that, sir?
State's Exhibit 264, Rogan.
All right. And is there a phone number associated with that?
There is.
All right. And we're not going to read that into the record, but have you had an opportunity to review the contents of that CD?
I have.
And what are the contents of that CD?
Subscriber information, cellular data information in response to a search warrant.
All right. And the contents of that CD are a accurate copy of the original records provided by Verizon to law enforcement pursuant to search warrant?
They are.
Okay. All right. And that's Exhibit 264, correct?
Yes, sir.
All right. At this time, State will move to enter Exhibit 264 into evidence.
No objection.
Submit it.
I hand you is marked as State's Exhibit 266. And you recognize that, sir?
I do.
All right. And what is that?
State's Exhibit 266, Connor Cook records.
And is there a Verizon associate and account associated with those with Connor Cook?
There is.
Have you had an opportunity to review the contents of that CD?
I have.
All right. And what is the contents of that CD?
Subscriber information, cellular data information in response to a search warrant.
All right. And that's a true and accurate copy of the records originally provided by
I would pay
Verizon
so
to
much money for
law
the defense
enforcement
to start
pursuant search warrant?
cross-saying.
That is
Can you
correct.
hear me now?
And what's
Well,
that number?
that's a good one. Thanks for super
State's
chatting.
Exhibit 266.
All right. This time, State will move to enter Exhibit 266 into evidence.
No objection.
Submit it.
And last one, this is State's Exhibit 267. I'm going to hand this to you. Do you recognize that, sir?
I do.
Do you recognize that?
I do.
All right. And what is that?
State's Exhibit 267, Buster cellular information.
And there's a number and a Verizon account associated with Buster's phone records?
That is correct.
We're not going to read that number to the record, but have you had an opportunity to review the contents of that CD?
I have.
All right. And what is the contents of that CD?
Subscriber information, cellular data information in response to a search warrant.
All right. And is that an accurate copy of the records originally provided by Verizon to law enforcement in response to a search warrant?
They are.
All right. And what number do you have? What number is that again?
State's Exhibit 267.
All right. At this time,
No,
State
Buster's
will
not
move
his
to
real
enter
name. His real
Exhibit
name is his
267
father's
in
name,
evidence.
but Junior.
Submit it.
Buster's real name is Richard Alexander Murdaugh Jr.
I'm going to hand you, this is marked as on the back, as State's Exhibit 270. Do you recognize that, sir?
I do.
Okay. And what is that?
This would be a key that is used to explain the VoLTE call detail with cell site explanation.
And is that originally come from a PDF provided with each of these search warrant returns?
That is correct.
And so that document will be found on each of those CDs, correct?
That is correct.
All right, and this is just a printed out version.
That is correct.
But is it exactly similar to the explainer on contained on those CDs, correct?
Yes, sir.
And at this time, State would move to Exhibit 270 into evidence.
No objection.
Submit it.
All right, sir. So let's talk about that document you have in your hands. I think you told us kind of what it is, but can you give us a little more detail? What does that do, and how does that help someone looking at these records?
In response to a search warrant, Verizon provides a key to be able to read the records that were provided.
Okay.
So this particular record is a Vultee call detail record key.
Okay, all right. I'm going to take this to you, and I think the Elmo is still up. We need the Elmo up, please. Okay. So looking at Exhibit 270, State's Exhibit 270, we see several columns of information across that. Is that correct?
That is correct.
Okay. Can you read from your screen there, sir? Can you read some of that information?
Yes, sir. The first column is record open date and time. The second, would you like for me to?
I don't think this guy's on the witness list.
Well, let's lay a little more foundation. The records that are provided on those CDs, and they're in digital format, correct?
That is correct.
And what program are they sent in?
Excel.
Okay, Excel format. That's a spreadsheet, correct?
That is correct.
And so when we look at these records, they're all provided in columns in Excel spreadsheet, correct?
That is correct.
And each column going left to right is a different sort of information that is on the records, correct?
That is correct.
All right. And so we'll look at an example in a few minutes, but this is the key to look at to understand what each column is in reference to, correct?
That is correct.
Okay. So let's look at the far left column, and I believe that says record open date time. What does that mean, sir?
That would be the date and time the call record transpired in local time.
In local time, okay. And what's the second column from the left?
That would be the date and time the call transpired in Greenwich Mean Time.
Okay.
I don't see this
Greenwich Mean
guy's
Time
name on the witness
is
list.
that also known as universal time?
That is correct.
And on June 7th of 2021, do you know the approximate offset for local time and Eastern time with Greenwich Mean Time? Would it surprise you if I said it was 4 hours difference?
That is correct.
Okay. All right. Okay. Going to the third from the left column, what is that?
That is the serving system ID.
And what does that mean?
That's a network name on Verizon from which the call transpired.
Okay. And what is the column next to that? I believe it's labeled NID.
That would be the switch number that Verizon uses to.
Thank you for the donation on PayPal.
And what is a switch, generally speaking?
From Joe.
It would be
Appreciate that.
what is considered a hub for multi-cell towers.
Okay. So multiple cell towers be connected to one switch.
That is correct.
And then going next, cell ID. What is that column?
That would be the specific cell tower that the target number used to make the cellular data connection.
Okay. And that's the actual tower that a particular call was routed through, correct?
That is correct.
And the next column says cell face. What is that? What does
That
it mean?
would be the cell face that the cellular data connection transpired over. There's typically 3 faces on each cell tower.
Okay. And next we see market ID. What is that?
That's fair. That is the switch number. So in some records it'll have that listed. So it's the same thing as the NID, but depending on the specific record, which column will be used.
Okay. And then next column says ENB. What is that?
It's a 6-digit cell tower number. The first 3 digits is the market ID, and the last 3 digits is the tower identification.
Okay. Next column says DIR. What does that show for, and what does it mean?
That's the direction that the call transpired over the Verizon network.
And when you say direction, you mean incoming call or outgoing call? That sort of direction, not north, south, east, or west, right?
That is correct.
All right. The next column says NSISDN. What does that mean, sir?
That is the Verizon subscriber.
I think I'm just going to keep the banner as is at this
And
point.
it says this is your target number.
Did I do a thumbnail
And
for
that's in
court this
reference to
afternoon?
the
Yes, I
search
just
warrant,
haven't
correct?
uploaded it
That
yet.
is correct.
And so when a
But I
search
probably
warrant
should
asks
do
for
that.
records for a certain number.
So I'll do that.
That's the target number, correct?
That is correct.
And that's what that column identifies, correct?
That is correct.
And next column says called number. What does that mean?
This is the number dialed to initiate the call. For inbound calls, this number will be the same as the mobile directory number, MS-ISDN column, and the out calls, this is the number your target dialed.
Okay, so simplifying it, it's simply the number that was called when someone placed a phone call, correct?
That is correct.
Next column is CPN. What is that, sir?
This is the calling party number that initiated the call. If the call is outbound, this column will be the same as the mobile directory number, MS-ISDN. If the call is inbound, this is a number that dialed your target.
Okay. And the next column says SOU. What is that, sir?
Seconds of duration.
Okay, and that's how long the call lasted, correct?
That is correct.
And the next column says RAT. What does that mean, sir?
That is the type of cellular connection that the data session or call transpired over.
And so we see several different categories underneath that. I see a 3G voice, 4G voice, and some others. What does that stuff mean?
The Verizon wireless technology that's used to allow that call to take place.
Okay. So 3G and 4G are different types of technology Verizon uses?
That is correct.
And depending on which tower and where the phone is located, it could be, a call could be routed over 3G or 4G. Is that correct?
That is correct.
Okay. Getting pretty close to the end here. The next column says VICE endpoints. What does that mean, sir?
It's a VoLTE connection with an endpoint, so that's a type of device that can boost the Verizon signal. It's an indicator if that was used or not.
Okay. And VO, you call it VoLTE. What is that?
Voice over LTE is a type of technology similar to the 4G.
Okay. And that's
Not-
a voice call that's routed over the digital network.
No,
That is
okay.
correct.
And finally, we see VZWNE, network extender. What is that column, sir?
That is a device that allows consumers to connect to a network extender to boost their indoor coverage. So there'd be a difference in the call type listed in the records.
So Verizon provides to certain customers network extenders for them to use in buildings to help them.
Witness
connect all the
176 on the
buildings.
list.
Correct.
That is correct.
And if a call were routed through such a connector, it would be listed in that column.
That is correct.
Okay, I'd like to switch over to the laptop, please.
Mikey Tony Satterfield?
Exhibit 270, in case you need to look
That
at
doesn't
it.
sound like the right name. Satterfield?
All right. And I'm going to pull up some of the records that were provided that we just talked about on those CDs. And the first one I'm going to pull up is the one associated with Maggie Murdaugh, and her number ends in 9041. And I believe that comes from exhibit. That's State's Exhibit 265. And let me get rid of the annoying. Okay, so we're going to scroll down, and we're going to talk about a couple of these calls just so the jury understands or can understand some of these records.
I will tentatively schedule this afternoon stream for 1:30 Central. And change it when the court gives me a more precise time, but I can post the link at least. January 31st p.m. That's what we need. That's the right thumbnail. Great. Publish that. Fantastic.
And I went too far. Bear with me, please. Okay, I've highlighted column 1846 on this spreadsheet. Can you see that, sir?
I can.
Okay. So let's walk through this particular call. All right. The far left column, column A, we see a number there. What is that number, sir?
That's the phone number that was associated with the search warrant.
Okay. And that's the 9041 number, correct?
That is correct.
Okay. And column B, I see a date that says May 1st of 21. What is that date, sir?
That was the date that the search warrant started the request for the search warrant.
Okay. So when law enforcement sent a search warrant to Verizon, they requested a date, a record starting on May 1st. Is that correct?
That is correct.
May 1st, 2021. And then the next column says June 10th of 2021. What is that date, sir?
That is the last day that was requested on the search warrant.
Okay. Yeah. All right. So in this case, June 10th was the last date from that search warrant.
That is correct.
All right. Okay. So let's look at column D. And what is column D in this record?
Thank you for the compliment on the
That is
thumbnail. I
the
appreciate that.
time that the actual call took place in local time.
Okay. And what time is that?
19:50 and 20 seconds.
All right. Can you convert military to civilian time? Are you good at it?
I am not good at it.
Okay. So generally you subtract 12, is that correct?
That is correct.
So would that be 7:50 p.m.?
That is correct.
Okay. All right. And then the next column, we see it says June 7, 2021 at 23:50. What is that column?
That's the record in Greenwich Mean Time.
All right. And so that's in the universal time, correct?
That is correct.
And can you convert that to local time? Well, subtracting 12, would it be 11?
It would be
11:50 p.m.?
50 p.m.
All right. Next column, there's a digit that says 13. What is that digit, sir?
Can you scroll to the top where I can see the header on that?
And we're looking at column I.
That is the cell face number.
All right. And so that is the direction based off what you previously testified, that is the direction the call is in the sector from the tower, correct?
That is correct.
I'm going to scroll back down. Bear with me, please. Okay, we're back on June 7th, and we're back at column 1846. So we just said the 13 was the direction from the tower, correct?
That is correct.
All right, and so we see a number next to that that says 459. What is that number, sir?
All right, I'll change his name.
That is the market ID.
Okay. And market ID.
I'll change his
again, what
name
does
to
that
be
mean?
nice.
That would
Had
be
enough fun with
the
it now.
switch on Verizon Wireless Network.
Okay. All right. And then next to that is column K, and that says, there's a digit that says 459240. What is that, sir?
That is the ENID. The first three digits are the switch. The second three digits are the cell tower information.
Okay. And so that identifies the actual tower that call was routed through, correct?
That is correct.
And then next to that, in column L, we see MO. What does that mean, sir?
Mobile originated.
All right. And what does that mean?
The cell phone in question to the search warrant originated the call.
So this means this call is placed with Maggie's phone, correct?
That is correct.
Okay. And then next to that, we see a phone number in column M, and it ends in 9041. Is that the target a phone number?
That is correct.
And next to that, we see a number that ends in 0853. What is that in column M?
That was the number that 9041 dialed.
Okay. And then column O, and we see that 9041 number again. And remind us why that number's there again?
That was the number that dialed the 0853.
Okay. And then next column P, we see 165, a digit of 165. What does that mean?
That is time in seconds.
Okay, so that's how long the call lasted?
That is correct.
And then column Q, it says LTE. What does that mean?
That's the Verizon technology type that was used to make the call.
Okay, so this call is routed over LTE, correct?
That is correct.
And that's a 4G technology?
That is correct.
I'm sorry, I wasn't paying attention. What has he been testifying
So
to?
let's look at the column below that.
I was too busy
That's
making fun
column
of his name. Has
$18.47.
he been testifying this whole time?
And let's just go ahead and look directly
I
at
just
column
got
B.
here. What's
And
happening?
that's the date where it says 2021 680104 24. Remind us again what that column means.
Which column?
Column D, and we see the date of June 8th of 2021, and there's a time that says 010424.
That is the time in Greenwich Mean Time.
Okay. Now, you previously testified that in column D, that time is normally provided in local time. Is that correct?
That is correct.
But in this particular record, we see a time in Greenwich Mean Time, correct?
That is correct.
Why is this, in this particular call, why is it in Greenwich Mean Time?
Because this call connected to Verizon, but the call was not answered on the cellular connection and routed to voicemail.
Okay. So, because this call was not picked up, the call is routed to Verizon server, right?
That is correct.
And because of that, Verizon records the record in Greenwich Mean Time.
That is correct.
But I hate to do this. Let's convert that back into local time. So subtract 4 from 0.24.
Are you sure subtract 4 is correct?
Would that yield a time of 9:04:24 in Eastern Time, sir?
That would be correct.
Okay. PM, correct?
That's correct.
Okay.
How do you?
All right.
You just
let's skip over.
You just said
column
that.
I, column J, and column K. I believe you said previously column K was the digit associated with the particular file calls routed through, correct?
That is correct.
Well, here we see in this one NA. Is that what that says?
That is correct.
What does that mean?
Yeah, it depends
What
on
does
the
it say in
daylight savings or
Well,
not.
the call
So,
didn't
like,
actually
yeah.
connect to a cell tower. When the call didn't answer and it routed to voicemail, it's an internal routing, so there would be no cellular data as far as cell tower information provided.
Okay. So a call was placed to the 901.
Hey, Legal Vices, thanks for dropping by. Would you
Oh
like a
my
link?
God.
And the
This
901
testimony has
phone,
been
most likely
riveting.
rang, correct?
I'll send you a
Howdy,
link anyway.
Kurt.
That is correct.
You know you're always welcome
No
to
one
join
else.
me, right?
That is correct.
And so Verizon did not record a particular cell tower associated with that call. Is that correct?
That is correct.
All right, well, let's finish up with this record. Column M, again, that's the target number, correct? 9041.
That is correct.
All right, and then we see in column N, as in November, 9041, again, the same number. And what does that mean?
That means the 1227 number dialed the 9041.
Okay. All right, and no one answered, correct?
That is correct.
And I skipped over column L, it says MT, and what does that mean?
Mobile terminated.
Okay, and so that call was not in fact completed, correct?
It was forwarded to voicemail.
Okay, all right. And after that 9:04 p.m. phone call, we see multiple more calls to Maggie's phone, correct? Or correct?
That is correct.
All right. And are any of those calls answered according to the records that Verizon keeps?
They are not.
All right. I'm going to shift to pulling up the call records for
Is the
the
state
number ending
is
in
the state trying to like
1227?
purposefully shut down my brain to like make me more
That's
pliable?
exhibit.
Is this some sort of like 720-degree underwater hungry heppo technique to make my mind so numb that I'm just receptive
268,
to anything they
and that's the
say?
number associated
Is
with
it part of the
Alex
brainwashing?
Murdaugh's phone, correct?
I feel like it might be part of the brainwashing.
That is correct.
All right. Bear with me.
All right, thank you, Legal Vice, for dropping by. Legal Vices is also streaming this. Kick ass. Thanks for dropping by, Legal Vice. We could stream snipe Legal Vices. That might be like mildly entertaining.
Okay. And let's look at column 2371. All right. You see that on your screen, sir?
Yes, sir.
All right. And we see a time, and column D, and that says June 7th, 2021, 21:04:24. Is that correct?
That is correct.
And this time is in local time. Is that correct?
That is correct.
And the quick conversion on that, or excuse me, so no conversion is necessary on that. So that's 9:04 p.m. and 24 seconds, correct?
That is correct.
And that is, in fact, the same time that we just saw in Maggie's records that we just reviewed, correct?
That is correct.
All right. And so we see, if we look over in column I, J, and K, we do have cell tower information for the outgoing call from Alex's phone, correct?
That is correct.
All right. And then we see that this is code MO. And what does MO mean again?
Mobile originated.
All right. So that means this account is placing the call, correct?
That is correct.
The account ending in 1227.
Is it part of a tactic
And it was placed to the number
to make
ending
me
in
like
9041, correct?
want to
That
get
is
out of here so bad that I'll just vote to
And
convict?
then,
Like
looking
anything
below
you
that,
want,
we're
just
not going to review
please
this
stop talking to
line
me.
by line, but we see a number of other calls starting at about 9:04 p.m. And onward over the next hour or two of calls made from the 1227 account, correct?
That is correct.
Okay.
CSK, in the interest of being technically correct, is the best kind of correct. I don't believe GMT and UTC change from leap seconds. I think it's only one of them. I think it's UTC that
No further questions
changes
from the state.
with leap seconds. I don't think GMT changes with leap seconds. How am I doing? Am I right? Please, someone tell me I'm right. How am I doing?
Apologize, the technology's about with me here. So you work for Verizon,
That is correct.
and you just deliver records to different people, or do you have a more, I say the word functional, but do you have a duties beyond just coming to court and delivering records?
Yes, sir. I work in executive relations, and I respond to subpoenas, other court records, and other type of cases that are associated with the executive relations team.
And obviously you have to have some understanding of what you're delivering, what these things mean, right?
That is correct.
And as I understand it, I'm going to ask you in a minute what some things mean. So do you see, is this on? Can you see that?
Yes, sir.
Okay. So if you look down, any way to put that up there? No. Okay, never mind. So if you look down at 6, 7, and if you look at, I'm trying to find some consistency here, those NAs in lines I and J on several calls above that, you see those?
I do.
What does that mean?
That means that the call was routed to voicemail.
So these are voicemails to Alec.
This record is for 1227. So based off of this record, 1227.
So like that call that
Dialed the 9041, but it was routed to voicemail.
Okay, that's him dialing out. But what about if you go up to 67 at 2208? Is that a call out or a call in?
Is that the line that you have highlighted?
No, I'm talking about go up to 67, maybe go highlight. Okay.
Which one is this?
6, this one, either one of these right here.
Here?
Right, yeah, that's fine. Is that an outgoing or ingoing call? Incoming call?
That was mobile forwarded, so it was forwarded to voicemail.
I get it's forwarded to voicemail. Was Alec making it or somebody else was making it? Who initiated the call?
The 7845.
7845. So that was a call into Alec.
That is
and
correct.
It went to his voicemail.
That is correct.
And tell me where I look on this to see what's outgoing and what's incoming.
Row L, or column L, MO, MT, and MF.
Okay. Okay, so MO means what?
Mobile originated.
He's the originating call.
That is correct.
Okay. What was the other one? MT. What does that mean?
Mobile terminated.
So he was getting an incoming call.
That is correct.
And MF?
Mobile forwarded.
What does that mean?
Routed to voicemail.
So there's two of them all of them mean voicemail. But what's the difference between MT, MO, and MF?
The direction of the call on Verizon's network.
Okay. Mobile terminated is he was making a call and it went to voicemail. MO
Oh
is
lordy, we
whoever
need
called
Blackleaf to give us some
initiated the
commentary.
call, went to voicemail.
No, MO means the cellular subscriber, in response to this search warrant, made a phone call out.
MO. So that would be Alex calling somebody went to voicemail.
Correct.
MT is somebody called him and it went to voicemail.
Mobile terminated means that our subscriber, in response to the search warrant, is the one that the call placed to and could have answered.
And so one of them's coming in, goes to voicemail. Another one's going out, goes to voicemail. And MF is what?
No, sir. MO means mobile originated, a phone call transpired over our network. So we could have answered the phone call. It would show up as MO.
We being who? Yeah, on this, if Alec had answered the phone call, it would have.
It would be mobile terminated because our subscriber answered the phone call.
Oh, okay. So MO, he answers it. Are you losing me or am I losing you?
We're all losing each other. I'm sure that much, Dick. I am quite sure.
Subscriber 1227 dialed out on Verizon's network.
Okay. And it was answered.
It could have been answered, yes. I mean, it was a call that transpired, and it would create a cellular connection, which would connect to a cell tower.
I mean, at this point, I talk over this testimony, but I don't know what to
Which
say.
record?
The MO.
How am I supposed to comment on this?
MO is mobile originated. Which
I got that part. I just want to know how you differentiate between these calls.
I could make more
one's going
accusations
out,
against Tug.
One's coming in, one's going to voicemail, either way.
That's fun, I suppose.
MF is mobile forwarding. So
Right.
that call would have went to voicemail.
Whether he was getting it or giving it. Whether he
Well,
was
if
making-
someone were calling him
Right.
and he didn't answer, then it would be forwarded to voicemail.
That's MF.
That is correct.
Okay, I got it. I finally get it. Took me a while. But again, I'm not a technological expert here. So
we could use Tug.
as you look
We
at
could use
his
Tug. Maybe
call,
Tug could make this entertaining.
to the extent that they are made.
Isn't
at
calling
certain
his own
times,
voicemail?
you can figure out whether
Why not?
coming,
I think
going,
people call their own
went to
voicemail all the
voicemail
time.
based on these records.
That is correct.
Now, can I see Maggie's phone? Just a second, please.
Tug was trafficking me last night.
Yeah, let's look at.
He was trafficking me in my chat. In his
Put
chat.
6'7" up high. So we went below 6'7".
My messages were in the chat being trafficked by Tug.
Phone calls starting at 7:02, and when we get down to
Tug traffics in cucumbers.
after that 7,
The cucumbers are changed through the experience into pickles. Hashtag pickle justice.
When is everything after that? Well, does she? When is the first time her phone goes to voicemail?
The 2340.
We could talk about
call
Atrioc.
went to voicemail. Then the next call log after that is a mobile originated, which means there were 2 outbound calls made.
That's exciting
And then after
stuff.
those 2 calls, the rest of the calls were routed to mobile telephone number 9041's voicemail.
What's the last time she made a call out?
So there's this very popular streamer called Atrioc.
What time
He
was
has
that?
a lot of viewers. He has like millions of viewers. He's
1950 is.
He's a popular streamer. And I'm, among other things, he's a gamer and he does some
7:50
fun
PM.
stuff.
That's the last call she
Gaming.
makes out.
He got busted.
That is correct.
He got busted
the last call
because
she
he
received
was
and
doing a
answered?
stream and he was displaying his desktop.
Well, the 2 calls
And one of the
that were
tabs
mobile
that he was
originated,
looking at
after that, the rest
was
of
the
them were routed to
Pornhubs.
voicemail.
But
Yeah, what
wait,
are the 2
friends,
calls
it gets
after
worse. Because the
please
tab
highlight?
was for a deep fake video
Complicated, I know.
of
even for
porn
you.
of 2 other
Any,
creators that are also quite popular in their own right,
So,
Pokimane
here.
and Maya,
At 7:02.
and also are his personal friends.
And then
And so he had a tab open for this
From her.
deep fake porn of his friends who are also quite popular streamers, and he had a whole cry session about it last night because he got busted. Oh, and incidentally, he had to pay for it.
at 7:02.
He had to pay for
Okay.
access to it because it was behind a paywall.
And was there any inbound
Well, there was also
were
that.
answered after 7:50?
So he had a little confession stream last night, and the salt is real.
There were not.
Okay, and one other thing. Just take that 7:50 and put it up at the top. Scroll, in other words, I want to see the calls after that. Okay, and this end.
So he had this
So-
he had the stream last night where he had his wife in the
In
background
fact, let's start with 6.
of the stream during the whole thing. Who was there, I suppose, the wife standing by her man, kind of shtick, as he's crying into the camera about getting
So how
busted
about look
for
at
watching
this
the
for
deep fake
6:09
porn.
and
that he
6:10,
picked.
and it stops at 6:10. Are there any outgoing or incoming or in other
We're
words,
talking about Atrioc.
any outgoing call first of all from that
Dude
phone
is married,
after-
yes.
on 6:09?
Mobile telephone
2.
number 9041 did not place a call outgoing.
Okay, what about any incoming calls?
The rest of the records are incoming calls that were routed to voicemail.
Voicemail. So the calls coming into her get routed to voicemail. No calls after 6:09 or further. Okay.
That is
now,
correct.
let me ask you this: text messages, are they shown on these records? You charge for them, right?
They are in a separate record, yes.
Were you asked to produce those?
They are in the file.
They're in the file. It's just we're not looking at them here today.
That is correct.
And are they reflected on this kind of same format?
Very similar. They have a separate key to translate exactly what each column and row means.
Okay. But you've produced those text messages.
So there's
for all
some
the phones
there's some
we're talking about
dramas
here today.
happening.
That is correct.
Were any other phone
Some
records
dramas
subpoenaed
happening
from
right
you
now in the
other
Atrioc
than the ones that you put
Ludwig
into evidence?
The only ones that I'm aware
Cinderella
of is the
Cutie,
ones that I have been
Maya,
received the records
Pokemon.
of.
Did you ask
May
for
you.
more records than these?
I did not.
Did the search warrant designate records other than these?
We would have to review the search warrant.
You don't have it with you?
No, sir.
Okay. Beg the court's indulgence for just a moment.
Call me after 7. Yeah, I remember those days, sure. So if I can figure out a way to grift off of it, I might make a reaction stream to it later. That might be fun.
What's the data retention policy for Verizon? How long do these records stick around?
Verizon maintains records for billing purposes for around 18 months. In response to a subpoena or search warrant, we do keep the detailed records on file for those search warrants.
But absent somebody serving a search warrant after 18 months, they're purged.
We no longer have that information on file typically.
Does anybody have them?
I mean, the billing information would be available like through My Verizon where you could go and look at your bill.
But this kind of information would not.
That is correct.
Okay, and when you indicate these calls went to voicemail, how long does a phone ring before it kicks into voicemail?
There's no set time.
Who sets it?
Well, it depends on how long it takes the network to locate the call. So when you hear a ring, when you're dialing someone, it's really just the network trying to locate. So the phone itself may never ring if the network can't find you.
And that may take 2 or 3 or 4 rings?
It could take 2, 3, up to 6.
So when my wife accuses me of being impatient and hanging up on her before she gets to answer the phone, you just told me it's because the network, in many instances, has not connected with her phone yet.
The network is locating your phone. When you hear the ringing, the network is locating where you are on the network.
And that could take a while. And so if I'm hearing 5 rings and figure she's not going to answer it, I want to leave a voicemail, I hang up. And so there's no voicemail, it's just an incomplete call on your records.
Well, I mean, if she didn't answer your phone call and let it go to voicemail, then it would ring out if the network
Maybe I
found
don't
you.
want to leave a voicemail. It's rang 4 or 5 times. I hang up before she can get to the phone.
Sure.
That solves a mystery. Thank you.
Does it, though? Does it?
Your Honor. Just to clarify, when the Verizon records indicate that a call is routed to voicemail, I believe you previously testified, that could mean the phone itself rang, correct?
That is correct.
But there's another condition the phone could be in as well. If the phone is turned off and someone dials that number, what would the Verizon record indicate?
It would route to voicemail.
And it would look exactly the same, correct?
Yes.
And there's no way to look at these records and tell whether a phone is off, just not answering, or potentially shut off or otherwise not connected to the network, correct?
That is correct.
Okay. Okay. That's all from this evening. Thank you.
One further. What about if it's in airplane mode? Would the same thing happen? Goes to voicemail, right? Airplane mode, it doesn't ring, doesn't answer. It goes to, would it go to voicemail?
The network would still try to find where you're located. So if you're in airplane mode, the network may not know where you are, so it would still attempt to ring.
And these records don't give you any GPS location on phones, correct? You can't get that GPS.
According to the records that I've seen, they have the cell tower information, but not the specific GPS.
Cell tower information, depending on how many cells are connecting it, sometimes, I mean, can be very, if you're in New York City and there are 5 cell towers, you can probably get it pretty close. But if you're in rural Colleton County or Hampton County, there's one over here and maybe one way back there, it's much more difficult to find a specific location, correct?
Your Honor, the state's going to object. This witness is not qualified and expert on location information.
You can say I'm not qualified to answer that.
Yes, sir.
That information,
Response if you want.
Senator, he can answer whether he's able to answer the question. However, he's not qualified as an expert.
I don't.
All right. You may answer the question if you can.
I would have no way of knowing. I'm not qualified as far as the triangulation of the cell tower information.
Is that what you were getting ready to say before he objected and said you weren't qualified, or is that something you
That
really
would be
are
a
qualified?
standard
You've never
response.
testified about locations before.
Repeat the question.
You've never testified about what cell phone tower location means and how it's used.
I testified to the accuracy of the records that were provided.
Okay, thank you.
Yay, it's over.
Call your next witness.
Thank God. Who? What'd you say? I didn't catch that.
Raise your right hand. You affirm the testimony about to give the court in this trial shall be the truth, so help you God.
I do.
Please see the witness stand. Please state your name for the record. Spell your last name loudly, please.
Paul David McManigal, MC, MANIGAL.
Okay, Paul.
Good morning, Mr. McManigal.
Good afternoon.
Oh, good afternoon. Excuse me. Where are you currently employed, sir?
I am currently employed as a sergeant with the Charleston County Sheriff's Office.
All right. And what are your duties there entail?
I'm currently assigned to the United States Secret Service as a task force officer on the cyber fraud task force.
Okay.
All right. And generally, in your work on the cybercrimes task force, what does that entail?
I'm a digital forensic examiner, so I'm responsible for gathering electronic data from computers, tablets, cell phones, DVRs, vehicle infotainment systems.
All right. And when you say task force officer for the state, for the Secret Service is a federal agency, is that correct?
That is correct.
But you're actually paid, and there's still an officer with the Charleston County Sheriff's Office, is that correct?
That's also correct.
Okay. In this case,
There he is.
you provided some records in June of 2021 by an individual by the name of Dylan Hightower, is that correct?
That is correct.
And what did he provide you?
He provided me with a electronic extraction from a cell phone that was extracted as binary data and not yet processed by forensic software.
All right. And when he provided that to you, did he tell you which phone it was from?
I believe he said it was belonged to Alex Murdaugh.
Okay. And that's the one he extracted from Alex Murdaugh on June 10th of 2021?
That is correct.
And what role, what did you do with that information that he provided you, or that data?
I was asked to redact potential client lawyer privileged information.
I like how he's wearing a United States Secret Service lanyard.
By reducing it down to a certain time frame that was more pertinent to
I
the
guess he's
case
really
and
proud of that.
potentially reducing
That's just
any
an interesting note.
privileged
He's wearing a United States Secret
communication.
Service lanyard.
Did you make the decision of what to remove and what not to remove personally?
I did not. The decision of what to remove was made by Price Summer with the Ninth Circuit Solicitor's Office.
And she's an attorney?
She is an attorney.
All right. And you then produced a
See,
redacted
how do I,
copy
like,
of the digital evidence, is that correct?
Need to update this
That
thing.
is correct.
And you provided that back to Dylan Hightower.
That is correct.
Did you provide any further analysis to the data itself?
How do I
I did
abbreviate
not.
sheriff?
Did you redact any call
Sheriff?
logs from that data you're providing?
Call logs were not redacted at all.
United States Secret Service.
Let's move on. You've also been involved in one other aspect of this case.
Okay, hopefully that works. Just by way of background, because some of you guys may not know or forgotten, the United States Secret Service primary mission is financial crimes. That's why they were created in the first place, is financial crimes. So the fact that he was doing work relating to this case is quite logical, because that's what the Secret Service primary mission is. Before they were part of Department of Homeland Security, they were part of the Treasury, because their primary mission is financial
Marked
crimes.
as States Exhibit 299.
So, the more you know.
Do you recognize that, sir?
I do.
What is it?
This is a chain of custody form from the South Carolina Law Enforcement Division, which we commonly refer to as SLED.
All right. And do you...
And the Secret Service is counterfeiting. That's also what they do. That's financial crimes, yeah.
And what date did you sign that form?
June 9th, 2021.
Okay. And that form is related to what phone exactly?
There was a Apple iPhone 11 that was collected and brought to me by Special Agent Ryan Kelly with SLED.
Okay. And was that phone locked when he provided it to you?
It was.
And did you, in your forensic investigation, did you attempt to unlock the phone?
I did.
Were you successful?
I was not.
And is that Paul's phone?
I believe it was, yes, sir.
Okay. All right. And at this time, State would move to Exhibit 299 to evidence.
Stephen asks, why do the financial nerds guard the president? Well, the financial nerds guard the president because of executive order. Now, here's one for the trivia buffs in history. Who signed that executive order and when? When did that happen? The Secret Service got charged with protecting the president. Which president signed the executive order and when did that occur? There's one for the history buffs in the room.
It's been marked as State's Exhibit 274. This is going to be for ID purposes only. Let me ask you if you recognize that, sir.
I do.
And what is that?
This is the iPhone 11 that was brought to me by Special Agent Ryan Kelly with SLED.
And that's the phone you attempted to unlock but were unsuccessful, correct?
That is correct.
All right. And I believe on that bag there's an orange sticker. Do you see that, sir?
Yes, sir, I do.
What is that orange sticker?
This is a sticker I place on devices that I have attempted to process or processed successfully.
The correct answer is that it was
And at this
Lincoln,
time, State's
and it was signed the day he was assassinated. Yeah, that's the correct answer.
This time, I'm going to hand you State's Exhibit 298. Do you recognize that, sir?
Yes, sir, I do.
And what is that?
This is also a chain of custody report from the South Carolina Law Enforcement Division, SLED.
All right. And do you recognize your signature on that form, sir?
I do.
What date, did you sign that?
This is August 12th, 2021.
And what does that form signify?
This is the date I returned the phone to Special Agent Kelly.
And at this time, State would move to place Exhibit 298 in evidence.
Lincoln was also the last president to commute a death sentence federally.
And so you attempted to unlock Paul's phone, correct?
That is correct.
Right.
And you were unsuccessful.
That is also correct.
Did you alter in
Moving
any
on.
other way the data that was on Paul's phone during that time?
No, sir.
No further questions from the State.
Cross-examination.
Good afternoon, sir. My name is Philip Barber. I'm one of the attorneys for Mr. Murdaugh.
Good afternoon.
I really just have one question. When you received this phone, was the battery completely dead?
The phone was powered off when I received it.
Did you charge the phone after you received it?
I did.
But do you know whether or not it was completely dead, battery dead when you received
I do not recall if the battery was completely drained.
No further questions, John.
Anything further?
Nothing from the state.
Thank you. You may step down.
Thank you.
Presumably, that's to open up the possibility that the battery was therefore not dead, and therefore something on the phone could have been changed. Was presumably the purpose of that question.
John Van Allen.
And if that's all you need from that witness, if that's all you need, that's all you need. Right.
Raise your right hand, left hand. You affirm the testimony about to give the court in this trial shall be the truth, so help you God.
I do.
Take a seat in the stand. State your name again for the record. Spell your last name.
Jonathan Van Houten, V-A-N-H-O-U-T-E-N.
Mr. Van Allen. Where are you employed, sir?
United States Secret Service.
All right. And how long have you been employed there?
This April will be 3 years.
All right. And are you currently a law enforcement agent?
I am not.
Okay. And you're a civilian employee of Secret Service?
I am.
All right. But you do have a background in law enforcement, correct?
Yes, I retired after 21 years with the Columbia Police Department as an investigator. For the last 10 years, I was assigned as a digital forensic examiner with the U.S. Secret Service.
Okay. And you were a task force officer?
Correct.
During that time?
Yes.
And you retired from the Columbia Police Department when?
April 20th, 2020.
And in this case, you were provided a phone by, I believe, Britt Dove. Is that correct?
Lieutenant Dove, correct.
I'm going to show you State's Exhibit 271. I want to see if you recognize this document, sir.
This is the SLED law enforcement, or South Carolina Law Enforcement Division chain of custody that was submitted to me by Lieutenant Dove.
All right. And do you recognize your signature on that form?
I did sign this form.
What day did you sign that form?
March 21st, 2022.
Okay. All right. At this time, State would move Exhibit 271 as evidence.
No objection, Your Honor.
Admitted.
Okay, I'm going to hand you State's Exhibit 272. Let me see if you recognize that, sir.
This is an evidence photo that I acquired of the device that was submitted to me.
You took that picture?
I did.
And do we see a sticker on the back of that phone?
There is a yellow sticker on the phone.
What is it? Can you read that sticker, please?
It appears to be some type of case number, evidence number, identified as an Apple iPhone, the model number with a SIM, and an agency case number.
And if you just read the case number and the item number.
7021-0204, item number 10.
Thank you, sir. So at this time, State moves Exhibit 272 in evidence.
No objection.
Admitted. All right. So I believe you said March 29th of 2022 is when Lieutenant Dove provided you that phone, sir?
March 21st.
Excuse me, yes, 21st. All right. And why did he bring it to you?
It's my understanding that the phone was locked, and SLED requested assistance of the Secret Service to unlock the device.
And at Secret Service, at that time, did you have tools available that could potentially unlock that phone?
Yes.
And did SLED have those tools, at least on that date?
At that time, they did not.
Okay. All right. And what tool did you use to attempt to unlock that phone?
For this, for my unlock attempt, I used a tool called Celebrite Premium.
Okay. And Sell by Premium is a way to potentially break into, lock phones, correct?
That is the only use for that tool.
And just generally speaking, how does a Cellbrite Premium attempt to unlock a locked phone?
It uses its proprietary software in an attempt to brute force the device.
Okay, what does brute force mean?
Brute force is if we don't have the code, we will attack the device, attack the data on the device to try to brute force the passcode to get the code for it to unlock the device.
And a device that's locked, why does it need to be unlocked for you to access the data? What underlying condition exists that prevents you from seeing the data?
Well, for Apple iPhone devices, there are two types of locks. There are before first unlock and after first unlock. Before first unlock is the phone is either powered down, it's been turned off and rebooted, or a code has been entered in too many times incorrectly. If you were to, an analogy for it, if you think of it as a bank vault, it is the before first unlock, at which we have to brute force the device, is like the big steel door.
Okay. And that underlying data is encrypted, correct? Otherwise.
Yes.
Okay. And you would not be able to read that data, correct?
I have to unlock the device to get to the data to decrypt it.
Okay. And so Cellbrite Premium, you said, attempted to do a brute force unlock, correct?
Yes.
Okay. And ultimately, was that attempt successful?
It was successful because I generated a predefined dictionary to attempt first prior to the tool using its own dictionary.
Okay. And what do you mean by that? What does that mean?
Well, humans are creatures of habit. They like to use numbers that are relevant to them. Most people will use their date of birth, an anniversary, a child's birth, the death of a parent as the access code. So what we do generally is we get as many social engineered codes or dates that are relevant to the particular phone that we will attempt first. Once that attempt is no longer viable, the tool will use its own dictionary to start a hardcore brute force process.
And absent kind of getting lucky with a preceded number, if the Cellbrite Premium has to brute force its way through and unlock a phone, how long would that take?
So for a 4-digit phone, if you had a 4-digit numeric PIN code, we're limited to an attempt of 146, maybe 145 attempts per day. So a 4-digit code has a maximum possible numeric value of 10,000 attempts. So at 146 attempts a day, it would roughly take a little over 2 months to 68 days to unlock that phone. Adding 2 extra numbers to a 6-digit, going from a 4-digit to a 6-digit, there are approximately 1 million possibilities now. At 146 attempts per day, it could take upwards 19 years.
All right. Now, you said that you can only do 146 attempts a day. Is that correct?
Based on technology at the time and current technology, technology is progressing, so it is getting faster.
Okay. Why is the software limited to just 146 attempts a day?
This is a security protocol chip built into Apple. It limits the time frame that somebody can attempt to brute force a device. The first is, it's an average of 1 attempt every 15 minutes.
Okay. All right. But ultimately, you said you seeded several numbers into Cellbrite Premium to give it some potential guesses first before just start going through all the other numbers, correct?
Yes. Once I start the brute force process, there is an option for me to enter my own dictionary or numbers that are relevant, that I think is relevant to the user of the device. In this case, I entered a number that successfully unlocked the phone rather quickly.
Okay. And what was that number associated with?
I believe the number was associated with the date of birth of Paul Murdaugh.
Okay. All right. And so once you successfully unlocked the phone, what did you do with it, sir?
I notified Lieutenant Dove that the phone successfully unlocked. I advised him that I was going to be getting a full file system extraction since I still had the phone in my possession. Lieutenant Dove provided me with an external hard drive to place the extraction on, at which time I did.
Okay. So you did a full file extraction and placed it on a hard drive, correct?
Correct.
Now, did you examine the contents of that full file extraction?
I did not. SLED has their own examiners. We did the extraction for them, but they analyzed the phone.
And so the data you placed on a hard drive and provided to Britt Dove, is that substantially the exact same data that you extracted from Paul's phone?
It is.
Okay. Is it changed in any significant manner?
It has not.
What do you mean by significant? You could have asked, did it change in any manner? But you didn't ask that. You asked if it changed in a significant manner. What are you trying to sneak in the door there?
State's Exhibit 273. Do you recognize that document, sir?
This is the South Carolina Law Enforcement Division chain of custody where I returned the phone to Lieutenant Dove.
All right. And do you recognize your signature on there?
I do.
All right. And what date did you sign that?
March 24th, 2022.
All right. And you then provided Paul's phone back to Lieutenant Dove, correct?
Correct.
At this time, state would move to enter Exhibit 273 into evidence.
Submit it.
Okay. And I'm going to show you what's been marked as ID. I believe this is 274. Do you recognize that item, sir?
Yes, this is the phone I received.
Okay. And that sticker on the back?
It matches the photograph that I took.
Okay. The photograph we put in evidence, the sticker on this phone matches that, correct?
It does.
Okay. All right, one last question, Mr. Van Houten. There have been a couple questions about Faraday bags in this trial. What is a Faraday bag, sir?
A Faraday bag is basically what it is a bag that shields electronic signals from entering or exiting the bag.
Okay. And what is the danger, by placing a phone in a Faraday bag, what is the danger you're trying to prevent?
We're attempting to prevent a remote wipe or remote destruction of the data on the device.
Once law enforcement takes a phone into evidence or custody, are there other ways to prevent a remote wipe?
Absolutely. Powering the phone down completely, not leaving it plugged to a charger, removing the SIM card, or the easiest is to place the phone in the airplane mode. It'll disable the cellular data and the Wi-Fi signal.
And you said that the danger is the phone could be remote wiped.
Yes, somebody with the account username and password could log into the iCloud account and set a remote signal. That signal will remain on the tower or on the network until the phone is reactivated. So, yes, somebody would have to have the username and the password to log in and commit that offense.
Okay. And was the phone that you did an extraction of, was it wiped when you received it?
It was not.
Nothing further for the state for this
Cross-examination.
No questions, Your Honor.
Okay, never mind
Thank
then.
you. You may step down. We will recess until till 2:15. Recess till 2:15. Please do not discuss the case.
All right, cool. Well, that's interesting stuff for sure. The defense, I think, had a pretty good day, poking holes in the evidence some more. The state's case is still kind of a little bit and to the extent that they are matching particular ammo that was found at the house versus the ammo that was found on the scene, they're not doing a really good job connecting that because the questions are too far apart, like for me to remember. And so they're like, well, okay, I remember something about, this brand name. I remember something about this gauge. I remember something about this dry lock. I remember some of these key words are familiar to me, but what you're not doing, and I have to assume the reason you're not doing it is because you can't do it. I assume that not all these details match. I assume that some of them match, but not all of them. is the reason you're not connecting it, right? So we were talking about this a little bit earlier, but we'll talk about it a little bit more. When you're talking about a shotgun shell, it can be matched a couple different ways, right? We talk about the gauge, which is how wide the shell is. We talk about the length. Typical here is 2 3/4, 3.5. That's the length. We talk about the shot size. That's how much the size of the pellets inside the shotgun, right? And then we can talk about things like the powder that's used and matching that. We can also talk about the type of shot, whether it's steel or lead or something else. In case you're curious, some jurisdictions, particularly with respect to waterfowl, ban lead shot. And so you have to use steel shot. And one of the reasons, typically, because steel is not as dense as lead, you either use a bigger shot or you use more of it to try to make up for the difference. So that's one of the reasons, in case you're curious, why these shots come in different sizes and different loads, is because, you know, when you move from steel to lead, you might have to adjust for that, but you can measure on those things. Anyways, so it would have been nice, to the extent it was possible, to say, okay, these are the exact same. But we didn't get that. And so I'm assuming that some of those details don't match. Some of those words sound familiar, but not all those words. It's like they didn't do the one-to-one comparison, which was really kind of interesting. So the lead ban for waterfowl is federal. Fair. Then what I said still remains technically correct. It's banned by some jurisdictions, but okay, never mind. Anyways, pressing on. Yeah. And the fact that if you're waterfowl hunting, you have to plug your shotgun so it only holds 2 rounds in the chamber is international treaty from the Canadian-U.S. Federal Treaty on the Migration Act. So, yeah. Anyways, federal is a jurisdiction. That's right. Federal is a jurisdiction. That's right. So what I said is technically correct, right? Anyways, yeah. So what it sounds like, and maybe this is not true, but it sounds like there's not a one-to-one match. And if there's not a one-to-one match, well, you got a bit of a problem, right? If it's just similar from similar company and similar stuff, I don't really think that cuts it. You know, if it's not identical, you know, I'm having some issues there. So yeah. And then we got Verizon guy who went on forever about something. I don't really know. Some calls that were made at times and places and things, and I don't know. There were things said, I think. I passed out. And then we heard from some Secret Service people regarding the phones that were found and breaking into the phones, which matters for some reason, which I'm not sure. So, yeah. You talk about column Q. Column Q is the best column. That's the sexiest column on the spreadsheet. It's column Q. Lord have mercy. So I'm not really 100% sure why this matters, except to the extent like we're going to determine when these phone calls did or did not occur, because that matters as to when. I mean, it matters in so much as determining how much time Alex Murdaugh had and stuff. So it's all set up for later, but right now it's a little bit late. They said they'd be back at 2:15, which is 1:15 my time. So yeah. So they'll be back in an hour, 15 minutes. I'm going to go ahead and adjust the time for this afternoon stream. Ugh. Just have to adjust it by 15 minutes. Great. Now it's 1:15. Fantastic. Okay, so this afternoon's stream is scheduled properly. Yay. So hopefully we'll connect some more dots, but right now it's not going great. And so, question: attorneys can consult with other attorneys when they have questions about what to do, but who do judges turn to? Can they call another judge? Yes. Yeah, absolutely. Judges consult with other judges. Judges consult with their clerks. Clerks are, of course, trained lawyers in their own right. And they consult with other lawyers. Sure. Absolutely. And if you're dealing with a particularly complicated case, judges can also appoint experts in their own right. That's a little bit rare, but it's possible. And so you can have a state-appointed expert, or a bench-appointed expert sometimes if the court feels like it needs an independent expert, independent of the parties, it can do that. And then you can even go like one step more, where the judge basically appoints a mini judge in particularly complicated cases where you call it a special master. And basically the judge just appoints a judge basically to help referee. That was one of the things that was used, for example, or to referee specific matters. They appointed a special master with respect to the documents that were took at Mar-a-Lago, for example. The court appointed a special master to deal with the evidentiary questions. And they are a servant of the court, so the court can ultimately ignore them and just do whatever the hell they want anyway. But of course, they tend to defer because why would they appoint them in the first place? But that happens where you appoint a special master to like deal with a special issue or stuff like that. The Supreme Court also uses them to deal with stuff where the Supreme Court has original jurisdiction. So they will appoint a special master, which in this case is almost always another judge. It's a federal judge to basically hear the case and then provide them recommendations, which the Supreme Court, of course, can then ignore completely because the Supreme Court is the court of original jurisdiction. So the Supreme Court can just do whatever the hell it wants. But again, why would they? So again, it's kind of a way for the Supreme Court to deal with cases where a lot of evidentiary issues need to be dealt with. So they kind of have a trial, a little bit, by the special master. They're also used in long-running cases, cases that run forever. In federal law, this would typically be like water rights issues. So where they need someone to supervise an ongoing thing that lasts for decades. There was also, in the case of like the aspirin settlement, they appointed like a special master to deal with that. Also, for example, when they were for like the FTX thing, basically the new CEO is basically a special master, basically. And he was appointed, I think, formally at some point as a special master with respect to Enron. And also, for example, the 9/11 settlement fund, they appointed a guy. And they appoint the guy as a special master, and it's like, congratulations, you're now the guy who gets to determine what families get to recover what money from the 9/11 settlement fund. Congratulations. This is your problem now. You get to decide how much each family gets, if anything, and how much their pain is worth. Yay. So there was So good. I'm not sure I'd want that job. That sounds like a lot of stress in my life. But that was just a guy. Just like, congratulations, you're in control of the whole settlement fund now. Go forth into the world. Yeah. Divorce cases have special masters in PA? Okay. Yeah. So those are some of the things that are used. So yes, judges, back to your original question, judges can do this on a whole range of formality, right? They can do this in a whole range of formality. So they can just like talk to their fellow judges at the water cooler. They can just talk to their clerks, which they do all the time anyway. They can appoint someone to help them as a subject matter expert. They can give them control of the case as a special master. So yes, that's some of the mechanisms that judges have when they feel like they're out of their depth. This is probably way too much information for you, but I'm happy to have helped. Also, I'd just like to say for the record that Peter Tregos' comments on the whole can you bring the conspiracy case were correct, right? So I gave the technically correct is the best kind of correct answer, and then Tregos, of course, gave the more practical answer, which we know we're both correct in our own right. So I liked what Peter said, like very much in his own stream. He's like, can you do this technically? Can you charge Murdaugh with conspiracy at some later point? Technically, probably. Practically, you're going to have many, many problems. Peter is correct. Peter is correct. To get past those many problems practically, it would help a lot if you had a confession and like an evidentiary trail that somehow magically appeared. That would help a lot. So if you found the co-conspirator and they had like documentation and shit that somehow you didn't otherwise have, that would help a lot get past those issues. But yeah, it's a problem because as Peter points out, like every state witness that's basically like, if this is a sole shooter, and now they're like, it's a conspiracy. Yeah. So there are pragmatic problems. There are pragmatic problems. There are other questions that I can answer before we break. We can also talk about the laws it deals with passwords versus other kinds of unlock. We've discussed this a little bit more. So for all you guys in the audience who are now concerned about your passwords on your cell phone, I will point out that if it is a password that you have to type in or swipe in versus face unlock or fingerprint unlock, this makes a fairly large difference legally. The Fifth Amendment protects you against compelled testimony. Testimony is contents of the mind. So in order for it to be a Fifth Amendment problem, compelled testimony, it has to be contents of the mind. So give us your finger to unlock the phone is not a Fifth Amendment issue because your finger is not contents of the mind. Give us your face for the face unlock is not a Fifth Amendment issue because it is not contents of the mind. Give us the alphanumeric password. Give us the numbers. Give us the swipe pattern. Now you have contents of the mind. Right? So just a FYI, if you want that additional protection, it makes quite a bit difference how you lock your phone. So if you use a password that you have to type in or a password you have to swipe in, now you have a Fifth Amendment argument. So there's that. That is the general thrust of the case law at the moment. Aaron says, read this. I am reading it. Judges can compel a key to a safe. Correct. For the same reason. The key is not the contents of the mind. Produce the object is not asking you to produce contents of your mind. In so much as it's because you know where they're stored, the courts don't care that much. So yeah, this all goes back to safes. Is the safe a combination safe or is it a key safe? This is where it all goes down to in the case law. Combination safe, contents of the mind. Key, not so much. Produce the combination is asking you to produce contents of the mind. Produce the key is not. Right? And it's like, well, only I know where it's stored. Yeah, the courts don't care. Because what they're asking for is the key itself. And that's considered distinct. So, yeah. So the judge can't force you to give the combo. Well, we're in a Fifth Amendment argument, and that's where things at least get complicated. But at least you have an argument. At least you have an argument. So can they compel it? Maybe under some circumstances. There's this inevitable discovery doctrine, which I think is a little bit bullshit. But it's possible. But at least you have an argument where you don't if it's not the contents of the mind. So, yeah. Also, incidentally, not contents of the mind, in case you care, just generally, although it's not necessarily relevant to this particular example, but why not, as long as we're talking about it. Also not contents of the mind. Appear for a lineup, right? Appear in a lineup is not contents of the mind. You're just standing there. A writing match. Write this statement. If the police are the one giving you the statement to write, like they're telling you the words, right? Write these exact words. Then not contents of the mind, right? They're matching the handwriting. So what's important is not the words that are being written. What's important is how they're being written, not contents of the mind. Vocal match. Say these words. Say these words, not contents of the mind. Because they're not coming from your mind. They're coming from the police's mind, right? So there's some additional examples for you. The 6-digit key will take 19 years if they have to go through all of them. So expected time is half that. And then, of course, in reality, it's much less because people use patterns. Like if you go look up most common ATM PIN codes, there's a list. Because people are somewhat predictable. So you don't have to guess all of them or even half of them. As he pointed out, with a little bit of intelligence, you can pull your down way down. So 19 years if we have to guess every single one, but we probably don't. Because, yeah. They can control you physically, not your thoughts. Kinda. If they're controlling you physically, you might have a Fourth Amendment argument because they might be forcing you to do something physically. Because now maybe they are like compelling you to be a place you're not, right? So maybe you're under arrest now. So you have a Fourth Amendment argument, maybe because you've been seized, ? But you don't have a Fifth Amendment argument. And we were talking about Fifth Amendment, right? So can the police force you to show up for a lineup? Maybe a Fourth Amendment argument, but not a Fifth Amendment argument. And these are why these distinctions matter to the lawyers. An Illinois school worker was charged with stealing $1.5 million worth of chicken wings? Okay. Wow. Go big or go home, I guess. Damn. So he was running a restaurant empire or presumably funneling the chicken wings to those who do, selling them on the cheap. Discount chicken man. Okay. Whether or not you can challenge the makeup of the lineup is a whole nother set of problems. Like that's a whole nother set of problems. Right? So just because you're in a lineup, does that mean that the identification from the lineup is necessarily good? No. Because now you can get into issues about the composition of the lineup. So, I mean, there's many places to attack. Right? It's just like, well, it's not a Fifth Amendment argument. Now we're on to something else, right? Now we're on to a different issue. Right. Just because it's not an argument for this reason doesn't mean it's not an argument for some other reason. And that's why law takes a lot of knowledge, because it's like, well, you got to know these things, right? It's helpful to know these things so that you know where all the areas of attack are. It's like, I can't attack it for this reason. I can't attack it for this reason. I can't attack it for this reason. Where else can I attack it? Right? I'll give you another one that's fun too. All right. The police lie to you in a lineup. Or the police lie to you, just generally. All right. The police lie to you in your interrogation. All right. So, like, what's your argument? What's the best argument that you have? This is a good trivia one for some people. What's the best argument that you have? I'll just give you the answer because it's a little bit obscure. It's a little bit obscure. The question is the police have lied to you in some way in the interrogation. Or we can even go further. Maybe the police. All right, let me try this. Let me try this to give you a better hypothetical, because maybe I'm not asking the question to prompt the answer. The police have come to you and it's in an interrogation. You're a young mom in this hypothetical. And the police have come to you and said, if you don't confess right now, we are going to go to child services. We're going to take away your kids, and you'll never see your kids ever again. Don't you want your kids? Don't you want to be able to see your kids again someday? You better confess. You confess. How do you get it suppressed? How do you get it suppressed? 2 words. Coercion's the right idea. Coercion's the right idea, but what are the magic constitutional words? Undue influence isn't bad. Under duress isn't bad. I'll give you a clue. I'm looking for 2 words from the Constitution itself. So I need 2 words that are in the Constitution. For the purposes of this answer, due process is the right answer, Joshua. Congratulations. Yeah, due process is the right answer. Congratulations. Good job. Joshua wins the prize. Yeah, due process. Shocks the conscience of the court. Right? Shocks the conscience of the court. So you can also do this like if the police fabricate evidence. Now, there's a key here. There's a key distinction. If the police lie about evidence they have versus fabricated evidence. So, if the police come to you with a folder and they say, in this folder, I have surveillance footage of you committing the robbery, but they're simply lying, they're allowed to lie. But if they actually have dummied up surveillance footage in there, due process. So these are the fun distinctions that you get to learn about when you play along at home. Yeah. Yeah. So if the police present a prop to you, like if they say we have shell casings from your gun, you don't have an argument. But if they actually show up with shell casings, you might have a problem, or they might have a problem. More to the point, right? Because now we're not just lying, now we're fabricating, arguably. They'll argue it's a prop, your defense lawyer will argue it's a fabrication, and off we go. But these are the distinctions we care about. Due process is not just how your case is prosecuted because of substantive due process. It's the substantive due process interest, which I know doesn't make any sense, but that's the law. So the law doesn't always have to make sense. It just is what it is. The concept of substantive due process doesn't really make sense, but it is what it is. And so, yeah, it's a substantive due process issue. Yeah, I mean, duress is the right idea. Like, you guys had the right ideas. Like, we were talking about duress, coercion. The fact that it's coerced, duressed, you got the right idea. I was just looking for the magic constitutional words, and Joshua got it first. So, but you guys were on the right track. You guys were on the right track. Doesn't it feel like lawyers just fight over words and definitions? Yeah, for sure. Yes, that's exactly what we do. Yes. Yeah, that's it. You got it. You've discovered our secret. Does it feel like lawyers just fight over words and definitions? Yes. That's it. You got it. That's exactly it. That's exactly what lawyers do. You've discovered our secret. We've been exposed. No. Good times. Yeah, that's where things get fun. Shall doesn't always mean shall. Well, rarely, but yes, occasionally there have been statutes that interpret that way. But with shall, the thing is, well, especially if you're talking about the Second Amendment, which is where, we have the fun discussions, right? Because shall doesn't really answer the question, as I've illuminated many times. So yes, occasionally you will have a statute which says shall and is interpreted as may, or the other way around, because the legislature sometimes makes mistakes, because the legislature is sometimes dumb. So there's a shocking concept for you. So sometimes the court looks at it and is like, I know what it says, but if you read the rest of it, they're just being stupid. And so what they really meant was this, because in context it clearly means this. So yeah, that happens because sometimes the legislature is dumb. So yeah, that sometimes happens. But if you're thinking about it from a Second Amendment perspective, like the right to keep and bear arms shall not be infringed. And like the Second Amendment, people say shall means shall. And I'm like, well, okay, that is only partially helpful. Shall what? And they say, well, shall not be infringed. Okay, that's only partially helpful. What shall not be infringed? The right to keep and bear arms. Okay, and now we have to sort of discuss this, right? This is where we start the discussion, in my view, right? So to say shall not be infringed is a little bit like saying, to say the right to keep and bear arms shall not be infringed is a little bit like saying the land shall not be trespassed. Before you can even have a discussion about what trespass is, you have to first define the land, right? I mean, that's kind of necessary. Right? It's like, oh, the land shall not be trespassed. Okay, but what's the land? Right? And so if this were a physical world, we can go out and, measure and survey and shit. But you have to first define the thing that you are or are not theoretically trespassing against before you can even have an intelligent discussion about what my trespass might be. So in the same thing in the Second Amendment, right? For my money, the place you have to start is what the right to keep and bear arms is. What is it? And to answer that question, you have to go back to the historical history that the right is based on, which incidentally is exactly what you do in any other constitutional context, by the way. This is not a unique Second Amendment thing. This is exactly what you do for freedom of speech, right? So why isn't slander part of the freedom of speech? Because it's not part of the freedom of speech. Slander might be speaking, but it's not part of freedom of speech. Freedom of speech does not include slander. It's not part of the definition. So it's not protected because it's not freedom of speech. But I spoke it. Well, you may very well have spoken it. It's not freedom of speech because it's not the freedom of speech, right? So, like, and to prove that proposition, that's relatively easy once you sort of go into it. So, to talk about the freedom of speech or the freedom of religion or the freedom of assembly or the freedom of press or the freedom of protest or anything, or the right to keep and bear arms, you first have to go to what it does or does not even include as sort of like a ground line principle. Then once you do that, then you can start talking about what it might be to infringe it or not. What does that mean? But these questions are complicated. So that's what that's how you sort of go to all that. And the problem, at least in the Second Amendment arena compared to the First Amendment arena, is that the First Amendment arena has had about, depends how we're counting, but let's say about 80 years worth of law. The Supreme Court started taking the First Amendment seriously. Well, Whitney versus California was the first time they kind of took it seriously. That was 1927. That was the first inkling that they were going to take the First Amendment seriously, was 1927. But even then, they didn't really take it seriously for a while. So yeah, if you want to go back to the beginning of First Amendment law, I go back to Whitney versus California as the first Amendment case, at least in my mind. 1927. So if you want to go all the way back to 1927, then you're talking about 100 years worth of law. But I think that's probably a bit misleading. Probably more 70 is probably closer to reality. So if we want to talk about the First Amendment, I can talk about it for quite a while because I have 70 years worth of case law to talk about. And I can talk about that in some detail because I know quite a lot of it because I've read a lot of those cases. The problem in the Second Amendment arena is we don't have that. We had Miller, which was 1930, like 8 or something, which is just a badly written opinion. It's just badly written. And then the Supreme Court didn't do anything with the Second Amendment until Heller, 2005. And then we had McDonald, and then basically not much. So the problem in the Second Amendment arena is, unlike the First Amendment arena, there are so many questions to be answered, and the Supreme Court doesn't seem in a hurry to answer them, and it's very annoying. I think this Supreme Court should take a couple Second Amendment cases every year, just because it needs the most development. It needs the most development to begin to answer these questions. Hey, did you ask me a super chat question? Let me pull it up real fast. I'm sorry. I got kind of my own little world. Which Fourth Amendment case is best, Santana or Payton? Let me take a quick look. Let's see. Santana's pretty good. Santana's pretty good dealing with the doorway being your own private property. Payton, let's see. Payton. Warrantless entry for a firearms arrest. I'll go with Payton as the more important case between the two. Thank you for your super chat question. What did you miss? The defense poking a lot of holes in the prosecution's theory of the case and playing the tape again at very slow speed, trying to determine whether it was I or they. And I think it's they, but that's me. You've experienced undue duress. The chief of police and detectives both lost their job. Ouch. I'm sorry to hear that happen, and I'm glad to hear there was some repercussion for it. Damn. I think the Constitution's fascinating. I think the law's fascinating. I think it's great. So much fun and interesting. It's the way we resolve our human. It's basically the culmination of the way we resolve our problems with each other. And I find that very interesting. When will our Third Amendment rights be respected? I have to tell you what, Senshi, my Third Amendment rights are being respected every single day. I have not had my Third Amendment rights violated even once. And I appreciate that the government is respecting my Third Amendment rights. And that's kick-ass. Third Amendment, by the way, is no quartering of troops inside people's homes. I have not had a single troop quartered inside my home. I don't know about you, but there have been no troops kept inside my house. So, yeah. Did I watch Runkle's birthday stream? I was on some of it. It was fun. It was good. You weren't asking me, though. What's going on at the Supreme Court right now? Not much, I think. Someone wrote an article about why the Supreme Court decided to kick in re grand jury after hearing it. I could read this article. Let's read this article. This will be interesting. Why the Supreme Court decided to unhear a case, which has got to be really annoying for the parties after spending all that time and energy and stuff. And the Supreme Court's like, just nah. It's like after briefing and having oral argument, the Supreme Court's like, we've never heard of this case. We don't know what you're talking about. That's got to be really annoying. After oral argument in re grand jury, the smart money would have predicted either the court would affirm the U.S. Court of Appeals for the Ninth Circuit or dismiss the cases improvidently granted. On Monday, it dismissed. In fact, one was left wondering why the court agreed to hear the case in the first place. Yet dismissal, also known as dig, did not mean the court had lost interest in the issue raised. Only the facts in the case were not the right vehicle. The case is a good vehicle is a shorthand way of just saying that the case is good for deciding the issue. Not all cases are good for deciding the issue. Cases are not always set up properly for deciding cases. So if you want your case to be decided by the Supreme Court, it helps a lot if it's not complicated by externalities. It helps a lot if it's clean. The case invited a court to analyze a simple but recurrent question. When a client confers with a lawyer and receives both legal and non-legal advice, and the non-legal advice cannot be disentangled, does attorney-client privilege protect all the advice or none of it? State and federal courts have said for decades the answer depends on whether legal advice was the client's primary purpose. Trial judges who have to make decisions in the first instance do not seem to have protested that. They're too hard. But petitioners in this case, an unnamed law firm that was challenging the federal grand jury subpoena for its client's communications, argued they were both hard and unpredictable. For the privilege to do its job, the law firm predicted predictability is necessary. The law firm first urged that the primary purpose test should be replaced by asking if legal advice was a client's significant purpose, but that test also carries an unpredictability risk. So in its reply brief and an oral argument, the law firm modified the test to ask where legal advice was a bona fide purpose, primarily if not even significant, which might be the reason they dug it, because they changed the position. So that might be the reason they dug it right there. Justice Elena Kagan correctly characterized the law firm's position as a big ask. Either one of the law firm's substitute tests would have expanded the privilege, which explains why 13 amicus briefs for lawyers, including the American Bar Association, supported the law firm. It's they, not small clients, who benefit from expanded privilege. No mixed brief support of the government. The questions do not reveal a right-left division. I don't think there is one on this issue, to be quite honest. I don't at least perceive it that way. That's likely because, unlike much of the court's business this day, attorney-client is not politically or socially controversial. Questions from the bench show no ideological split. Rather, they reveal concern over the scope of secrecy that would ensure if either law firm's protests were adopted. Informally, this may be labeled as the lawyer in the room problem. Can the client ensure privilege for communication that standing alone would not be privileged through the expediency of including a lawyer in the conversation, no matter how modest? This is what they're concerned about. They're concerned about just seeing the lawyer on the email, and now suddenly it's privileged. That seems like that's a problem. Or just having the lawyer in the room. That seems like a problem. Just an answer would favor clients wealthy enough to add a lawyer to the room. And it would give law firms more business. And would protect corporations a lot more. Chief Justice Roberts asked the accountant who compiles a complicated tax form. His work is not privileged. Not under attorney-client privilege, it's not, because he's not an attorney. Right? But then the form is shown to a lawyer who identifies 3 items that are kind of iffy and bills $200,000. Would it then all be privileged? To me, the law firm counsel said that's clearly privileged. To which prompted Justice Thomas to ask, is there any non-trivial role the lawyer plays in the example that does not meet your test? Only if the lawyer's test was mechanical tax prep. So if he's just back to being a pure accountant. So that's pretty wide privilege. An exchange with Justice Jackson led to an unforced error. Jackson described a meeting that everyone agrees is a business decision, but the lawyer in the room adds a point. And you say as long as it's legitimate, that's enough to require that the entire thing be privileged. Why should I worry that using your test now we're going from one extreme to another? This is a very valid concern. This is a very valid concern. Levin replied, I just don't think that's going to happen. It would totes happen, by the way, like 100%. I know that has not happened under case law now, but you're changing the law, so it would totes happen for sure. Like 100%, 110%, I can guarantee it would happen. Of course it would happen. You'd have to be stupid for it not to happen. The absence of any kind of disagreement we become accustomed to leaves justice one to wonder why they did not simply affirm the Ninth Circuit. The easy explanation is that the record, much of it is shrouded by grand jury secrecy, which is not the right vehicle for the court to address it. Fair enough. Fair enough. It could be presumably adjudicated again at some later time. Once things are not, so that's possible. But there's another explanation. The majority of the court wants to save the issue for a case whose public facts permit a serious evaluation of the case question, where an answer can expand secrecy and greatly affect administration of justice. Yeah, I think that's fair. I think that's a fair view of the thing. So, you know. Cherry and Max says totes. Totes. Totes, for sure. Other word, totally. Yes, completes. I'm valley girling it over here. So, yeah, that makes sense. Okay, I'm going to take a break. I will be back in about 30 minutes with more riveting commentary, I'm sure. And back with more of your legal questions and stuff, and we can discuss more things. And I'll try to come up with more legal trivia questions or something. I don't know. I'll think of something. Nothing's coming to mind. All right. I'll be back. Love you guys. Lol.